Judgment 1501.
Appeal is dismissed.
Judgment 1502.
Upon an NCS consideration of the statutory scheme of the Government Grants Act and the authoritative pronouncement of this court, the legal position that emerges is no longer Rasandegra. Section 3 of the GG Act embodies a clear legislative mandate that every government grant shall take effect according to its tenor, notwithstanding any rule of law, statute, or enactment to the contrary. The expression any rule of law, statute, or enactment in the provision is of the widest amplitude and admits of no restrictive construction. Section 3 of the Government Grants Act confers upon government grants a special statutory immunity and elevates the stipulations contained therein to a position of supremacy. The provision is not to be read as a mere ancillary clause to Section 2, nor as a limited exclusion confined to the TPF. Rather, it constitutes an overriding declaration that the grant shall prevail in accordance with its tenor, even if such tenor is inconsistent with general statutory law. We are therefore of the considered view that the correct interpretive approach to Section 3 of the GG Act is a wider one. This section does not admit a narrow construction that dilutes the supremacy accorded to the terms of the grant. In view of our categorical finding that the DRC Act has no manner of application to the present list, the very foundation upon which the learned ARC assumed jurisdiction to entertain the eviction suit by the respondent stands eroded. The eviction proceedings having been instituted, entertained, and decided under a statutory regime alien to the legal character of the relationship between the parties are thus vitiated at their inception. The High Court, in affirming the said course on the premise that the respondent would otherwise be left without a remedy with respect misdirected itself, the existence or absence of a remedy cannot determine jurisdiction. Equally, in the absence of any express stipulation in the lease deed providing for eviction on account of non-payment of rent, no such right can be inferred. The grant must operate according to its tenor, and its silence cannot be converted into a ground of forfeiture. The respondent's right, therefore, is confined to recovery of rent in accordance with law. The appeal is allowed.
Main signature the one.
Please, this matter is coming now. Both may note to be deleted, my lords. Two times it note to be deleted, or 2 times it has carried forward. My lords have issued a.
It is coming on our
4th of May.
4th of May, not to be
Deeply obliged.
My lords, in item 802, I have filed an IA seeking appropriate directions. My lords, this honorable court had granted an interim stay on the operation of impugned order. Despite the same, the municipal authorities have encroached upon my property. They have started.
File a contempt. If there is an interim order,
Please, my lords.
And yet it is not followed, then the remedy is to file a contempt, not further.
My lords,
Yes,
only
rejected.
for the purpose of stopping the further construction.
Mentioning rejected.
My lord, may I mention, my lord, with your lordship's permission, can I mention item 112 to respond to? May I respond tomorrow? I've got a part 3 in 8, which I'll finish today. Only my response can be tomorrow. My learned friend can finish today.
Yes.
Obliged.
Next.
May I mention item 119? My lord had sent the matter for mediation. My lord had sent item 119 for mediation. Still going on. We're still negotiating. The next session is on 27th, the coming 27th.
Okay. After 2 weeks, sir.
Yes, great. Any specific date, my lords, may put it on?
After 2 weeks, 13th May.
Great.
Yes.
Please, my lords.
This is an application for the suspension of the sentence while pending the appeal, my lords. Whereas the appellant number 1, my lords, has undergone 16 years, more than 16 years of the sentence, and whereas the appellant number 2 has undergone more than 15 years of sentence. Page 13 and 14, my lords.
We'll hear the appeal.
Please, Madam,
Triple murder, triple murder.
It's a murder.
Triple murder.
While issuing notice, my lords have said that only with respect to that legal issue will be considered, my lords.
Let the appeal
Please, Madam.
be listed for hearing on 12th of August. Yes. Letter adjourned.
Manoj, this is the case where the complainant was known to me my entire life. He belongs to the same village. After 20 years of my service in the Indian Reserve Battalion, he says that this guy forged his age certificates to get into the force. Manoj, now your lordship has granted interim protection. I have joined an investigation. In the counter reply, they say that the departmental inquiry has been finished. Manoj, regardless of the decision, my submission right now is if the departmental inquiry stands finished, then what is the requirement for my custodial investigation?
Yes.
I have already presented my 10th grade mark sheet. Your lordships have on multiple occasions held that is the ultimate proof of age.
Yes.
Regardless, without going into the merits, my lords, if the departmental inquiry is finished, then there is no requirement for me. I have joined investigation.
Yes.
My lords, I'll address the departmental inquiry. He has been found guilty and dismissed from the service from IRB. We have filed the counter reply. It is not on record yet.
This FIR was lodged after 23 years.
Yes, my lords.
My lord,
2002, he
my
entered
lord,
the service.
the complainant from his village informed, and we got the in the recovery we were able to recover the exact document which proved that he has manipulated the birth
My lords, they
certificate.
put nothing on record to show which documents are they referring to. There's one document that they refer to, my lords, in the High Court. I have placed that on record. That is
that he has been found guilty of from the services departmental inquiry.
Petitioner has allegedly forged his date of birth in his matriculation certificate and used that certificate to secure recruitment in the Indian Reserve Battalion as a constable.
yes,
Full stop. This happened in the year 2002. Full stop. The present FIR was lodged on 26th August 2025.
No, my lords. This was launched in, my lords. Yes, my lords.
Date of FIR?
Yes, my lords.
26 August 2025.
25. That is after 23 years of the occurrence. Full stop. State Council informs that upon completion of the departmental inquiry, petitioner has already been terminated from service, and the fact of forging of date of birth has been established in the departmental inquiry.
Yes, ma'am.
Full stop. Parent. Be that as it may, comma, considering that petitioner has already been granted interim protection and the delay in lodging the FIR, we are inclined to make absolute the interim order dated so and so accordingly. So and so. Yes.
Grateful, ma'am.
Obliged. Well, this is the case of kidnapping and murder of a 7-year-old child. High Court has granted mechanically the bail to the accused because on the ground that the appeal will take considerable time. It will take years of time to decide the appeal. But without the gravity, High Court granted bail in mechanical order.
He was in jail for more than 10 years.
9 years or 2 months.
Yes, almost 10 years.
Almost 10 years.
Yes, his appeal will be decided. Considering that the High Court has allowed the prayer for suspension of sentence made by respondent number 2 and 3 herein on the ground of his incarceration for more than 9 years, we are not inclined to entertain this SLP. Accordingly, the SLP is dismissed. However, the appeal pending before the High Court shall be decided on its own merits without being influenced by any observation made by the High Court in the intent order. Yes.
because time may be granted to decide.
You make
manner.
you make a prayer.
By total lordship.
Yes.
They have page number 32, madam.
Page number
32.
Page number?
Page number 32, madam.
Jamtara.
Jamtara. And co-accused similarly placed has been granted bail. And my lord, in this case, no offence has been committed. My
Submits that similarly placed co-accused has been released on bail by the High Court.
my lord.
It's a notice. Tenable in 6 weeks.
Next.
Against the rejection of the regular bail matter. I'm in custody since from 8/8/2018.
That is the only thing in your favor.
My lord, the alleged main conspirator has been granted bail, my lord.
No. You are the main assailant.
No, my lord, as per the FIR, my lord, the
You need to notice because of your long incarceration, but I don't think
my lord,
anything will come out.
my lord.
Considering that petitioner is in jail since 8/8/2018, issue notice to be issue notice to be respondent. Considering petitioner is in jail since 8/8/2018. Next, issue notice to the respondent.
Obliged.
Returnable. Today is 22nd है ना आज?
जी.
Returnable on 26th May.
Obliged.
Brother-in-law of the deceased, my lord. The deceased committed suicide on account of the matrimonial dispute, my lord. My lord has considered the interim protection of the mother-in-law annexer P4, my lord.
Yes.
Annexer P4, my lord, similar set of allegations, my lord, has granted the
Lady, she is a lady.
his mother-in-law.
Lady.
This is the regular.
You are not a lady.
This is the regular. That is anticipatory. This is the
My
regular.
lord. Yes.
Regular allegation against the present petitioner that the on account of the matrimonial dispute, my lord. He has visited the matrimonial home of her sister, my lord, and extended threat, my lord. Except the allegation in the FIR, there is no other case, my lord. There is no other evidence to show that he has extended threat, my lord. Abatement is not made out, my lord. His distant relative.
Any suicide note is there?
No, nothing.
I am appearing on behalf of complainant in this case.
There is
No, video is
Video
not.
clip.
Video is the act of committing suicide.
yes.
He has recorded himself, my lord.
Any evidence of abatement or the nature of allegation which may constitute abatement.
No.
My lords, I am appearing on behalf of complainant in this case.
Commission of suicide and video of commission of suicide would not constitute ingredients of 107.
My lords, may I submit, my lords?
Yes.
My lords, I am appearing on behalf of complainant in this case.
So notice.
My lords, let us be pleaded as a party in this case. My lords.
Renewable on 28th May. Complainant be pleaded
Grateful, my lords.
as respondent.
Grateful, my lords.
Memo of parties be corrected. Yes.
Please, Your Lordships.
Yes.
This is a fresh bail application, Your Lordships.
Yes.
Wherein the victim itself stated that she is in a love affair with the person, my lords.
What
and one of the
affair?
co-accused has been extended on bail, Your Lordships.
What
Is it-
affair
yes,
is
please.
being used by your brother also? Your brother, everything. Sorry, not a case for bail.
This is what the
Dismissed.
my lords, this is an allegation. My lords, one of the person has been on bail, Your Lordships.
We are not inclined.
My lords, no.
Yes, next.
My lordship, the parties have settled. I'm seeking liberty to withdraw the SLP, Your lordship.
Dismissed as withdrawn.
Grateful.
Please,
Yes. Yes.
Here, my lord, the High Court directs
Yes.
that the factory will be sold as a going concern. Now, my lord, in this suit, this is a very profitable firm operating in Bombay, even today. A suit is filed because of interstate dispute among the partners. Notice is issued in the suit.
Yes.
26 years ago,
Yes.
and no dissolution takes place. No order for dissolution, but I'm proceeding on the assumption that dissolution has taken place. Yes, Lord? Now, my Lord, the industrial court hears the matter. And the industrial court says two things. One is 25O permission is mandatory under the Industrial Disputes Act.
Your interest has been protected.
Not at all. I got only my closure compensation.
Closure
of 3 lakhs.
What more you get?
2506. My Lord, kindly turn to my note. See page 1. I've set it out there.
Yes.
My note for arguments. My Lord Lordship has that. My note for arguments. 24/3/26.
This additional affidavit come written submission.
Yes, sir.
Yes.
Kindly turn to page 1. And on this, we have two leading judgments of our court. 2506.
Yes.
Now take 25O, procedure for left hand side. Closing down an undertaking, an employer intends to close down an undertaking, shall in the prescribed manner apply for prior permission 90 days from the date of the intended closure to the appropriate government, stating clearly the reasons. Now we are concerned with 6, and this is the subject matter of 2 cases. When no application for permission under subsection 1 is made within the period specified therein, or where the permission for closure has been refused, the closure of the undertaking shall be deemed to be illegal from date of closure, which is a long time ago.
Yes.
And the workman shall be entitled.
What is the finding on this issue by the High Court?
The industrial court holds in my favor. High Court says 2 things, but can I show you the industrial court order first, my Lord?
Yes.
Yes. See, my Lord, the industrial court order. Give me the page number. Take it page 2 of my note. Industrial court order is basically correct according to us. Paragraph 6, page 2. Lordship has that?
Yes.
Held that no court order directing closure of business of the firm, and on the contrary, the High Court had directed the court receiver to explore the possibility of selling the factory as a going concern. Yes. Then, my Lord, the second finding. The court receiver acted illegally in disregarding the provision of 25O, particularly 2506, and there is no legal dissolution of the firm, and that the employees continued as employees of the firm.
You have not been paid wages for last 25 years.
25 years. And this is one of the leading firms in Mumbai. Now, what they do, my Lord, I'll tell you, Lordship. The partners.
You have been terminated or what?
Just left in the lurch. Families died, people.
Notice.
Grateful. There's a 19 days delay, my Lord.
Delay condone.
Grateful.
Letter. Urgent.
31.
Yes.
In this case, may I request your Lordship to have it next week, my Lord? The conversation, my Lord, which was placed along with the status report before the High Court, I would like to have that on record.
Mike, please use mic.
My Lord, the conversation which was placed along with the status report, I would like to place that on record. That was in Punjabi, my Lord.
As straight post in the next week.
Next Thursday, my Lord.
Hello, Rest.
Happy to.
Okay.
Yes. Wednesday, it will be on Wednesday. Mr. Khanna, it will be on Wednesday. Yes, Wednesday. Last working day. Yes.
Your Lordship kindly pass on the main reason.
Pass.
Happy to. Well,
Well, then 12 they came against an interim order. In terms of my lord's order dated 10th of February, 16th of February, we have filed charge sheet on 16th of March.
Not here. Petitioner is not here.
Please, my lord.
Passport.
He is just. He is here.
Yes.
Yes.
No, they indicated that the charge sheet is filed. I am assuming
On 16th of March, it has been filed.
and he is not being let off. So, Lordship, but trial may be expedited, matter will be disposed of. There is no problem.
It is informed by the State Council that during pendency of the SLP, the charge sheet has already been filed on
16th of March 2026.
16th of March 2026. In view of the above, nothing survives in this SLP for consideration. Accordingly, the SLP is disposed of as infectious.
Lord, one request, because Lord, I am a lady based out of Kanpur. So far as they have not at all reached out to me for any purposes, I don't know how they have investigated this. Lord, wherever my assistance is required, I will be permitted to join through VC as a complainant because I am in Kanpur. And he's a police officer.
Can always do. They can
Everything, you want everything in this SLP, which is arising out of his petition under 42.
I'm only
Sorry.
placing it for your Lordship.
You first approach the court and then if you have any difficulty.
Very, very deep.
Next.
In that case, I'm grateful. Deeply obliged.
Please, Your Lordship. In 13, the respondent had circulated a letter requesting 1 week.
Letter.
Their request instead of 1 week, can it be 2 weeks? Because
After 2 weeks.
Let's make me listed next week because next to next week there is a difficulty.
Then
Then
today.
after 3 weeks.
Then today.
It's next week.
No. After 2 weeks. Next.
What is my job?
What cost has been deposited?
Yes.
Cost of 30,000 has been deposited. And I have also filed the renewal.
Cost. We have import cost. Yes.
Yes, we don't have any problem with being together since the settlement. And now this
You are settled.
Yes, sir. I will be continuing 7 in the.
Yes, it is there in the High Court order also.
There's another affidavit filed in this SLP also. Page 57, my lord, please share it.
The main petition was for
Passing of the.
take petitioners preferred restoration application for restoration of the main petition under section 482 CRPC, which was dismissed for want of prosecution on 28/11/2024. The restoration application was allowed subject to payment of cost of rupees 30,000. However, the petitioner failed to deposit the cost and thereafter moved another application, moved the subject application before the High Court for extension of time to deposit the cost. The High Court has rejected the prayer for extension of time and as a consequence, upon his failure to deposit the cost, refused to restore the main petition. In our order dated 12th March 2026, we allowed the petitioner to deposit the cost of rupees 30,000 before the registry of the High Court in terms of the order passed by the High Court on 21/1/2025 in CRM DES 1938 DES 2025 within 4 weeks. Full stop. When have you deposited?
1st April 2026.
Petitioner has deposited the cost of rupees 30,000 on 1st of April 2026. The deposit was to be made where?
In the High Court.
Which High Court?
Punjab and Haryana High Court.
Bar Association is not High Court. Your receipt is Benevolent Fund, Punjab and Haryana High Court, Bar Association. And our order is to deposit before the registry of the concerned High Court. Bar Association office is not registry of the High Court.
The order the High Court says to be deposited in the by the petition with the Punjab and Haryana High Court Bar Association Benevolent Fund.
Which is that order?
My lord, we only have page 5. We have the order by the High Court which has been quoted on
Page?
Page of 4. Italics part number, the lower part of it. Yes, no. Now we find the cost of 30,000 to be deposited by the petitioners.
So then it should have been pointed out when we passed the order that the deposit is based to be made before the Bar Association, not before the High Court.
That is true.
Our order is say something.
My lord, we will deposit again, my lord. We will deposit again, my lord.
Not that.
The High Court cannot
Say something else. In para 4 of our order. Improve yours.
What may complete possible.
No. What possible? Hardly 1 minute. We have said in terms of the order of the High Court.
Yeah. Yes, ma'am.
Then read and convince us.
We have deposited in terms of the High Court.
There is some contradiction in our order.
In our order dated 12/3/2026, we allowed the petitioner to deposit the cost of rupees 30,000 before the registry of the High Court in terms of order passed by the High Court on 2021/1/2025 in CRM number dash within 4 weeks. The petitioner has deposited the cost of rupees 30,000 on 1st April 2026.
Before in the benevolent fund of the Punjab and Haryana High Court Bar Association. As directed by the High Court. Full stop. Para. Otherwise, you have compounded the offense. Both the parties have compromised.
Yes, sir.
It is informed that the parties have already entered into a compromise. In view of the above, the appeal is allowed. Appeal is allowed. The interim order of the High Court is set aside, and the main petition. What is the number of the main petition?
CRM M 47541/2020. Top of 6
Main petition before the High Court is restored.
Number like this.
Number, yes. Which is that number?
Page 4, I can put the top. CRM-M-47541.
Meeting number so and so is restored to its original number. Next.
I appeal for the respondent, in terms of my lord's order, the mediation is successful because the report is before my lords. We have filed an application under Article 142 also, lords.
Where is that? The application? You have filed it when?
We filed it yesterday.
There is no jointly application.
It is not a joint application.
There is not. Petition is present in person here
No,
on the last date.
do you agree with that application or not?
No, sir.
Then how come there is a settlement?
On the last date, Honorable Court ordered to present both the parties in person.
But my lords, that in divorce petition, my lords, before the case she wants to be transferred, my lord, they filed a settlement agreement on certain amount. Then she doesn't agree. First mediation was referred, my lords, she didn't turn up. And then was on our request, my lords, the second mediation was conducted, my lords. That mediation is successful. And now today, or prior to this, she was saying that
we have recorded in our order of 15/1/26 that mediation is unsuccessful. Then we again refer the party.
On 15/1.
And again it is unsuccessful.
No, my lords, it is successful now. She has signed on the settlement and a successful mediation has taken place.
So last mediation was on the pretext of compromise by the respondent that we will live together after this case.
No, because there is no question of living together at all, my lords. These are my instructions.
We agreed for divorce in the mediation. In the mediation, you agreed for divorce.
My lords, yes, sir. But after that, they compromised with each other.
Where is that?
No, there are no talks after the mediation. There are absolutely no talks. That the
what about this mediation report on recorded on 9?
So that is admitted. That is admitted. But
settlement is admitted.
Sir, she will explain it.
सर 9 फरवरी की बात है, मैं आई थी यहाँ पे, तो इन्होंने मुझे बोला था कि तुम ये बोल दो कि मुझे कुछ नहीं चाहिए और मैं फिर तुम्हें कोर्ट में बोल दूंगा कि मुझे साथ रहना और मैं डिवोर्स का विड्रॉ कर लूंगा और सारे सेटलमेंट यही हो जाएंगे। सर उसके बाद हमने बोला कि हमें नहीं चाहिए। फिर मेरे फादर इनके घर गए, हमने बात की तो बोले हम तुम्हें बिल्कुल नहीं रखेंगे और अब तूने साइन कर दिया, अब तू कुछ भी नहीं कर पाएगी। उसके बाद सर हमने सर को बोला, वो बोले कि आप कोर्ट में आ जाना, अपनी गवाही दे देना जो आपको करना है। फिर सर जज सर ने बोला कि आप क्या करना चाहते हो? मैंने कहा सर अगर हमें हमारे भरण पोषण के लिए हमें कुछ दिलाया जाए, नहीं तो सर हम ऐसे कैसे रहेंगे? सर हम प्राइवेट नौकरी करते हैं, 4 साल से हमें 1 रुपया भी नहीं देते हैं। इसलिए सर उन्होंने बोला कि फिर कितना चाहते हो? हमने बोला कि हमें सर 16 दिला दो। तो जज सर ने बोला कि या तो 16 दे दो, नहीं तो केस ट्रांसफर कर देंगे। उसके बाद सर ये बोले कि हम उनसे बात करके तब बताएंगे अगली डेट।
पिछला आरोप की देखूं
तो सर 1 वीक की डेट लगी थी 14 तारीख की, फिर 14 से होके वो फिर 22 की हो गई। सर
लगा था मेरे ख्याल से हम लोग बैठे थे
सर वो जज सर ने अगली डेट पे आ जाओ।
That was a simple order for asking both the parties to be present. The
settle the amount here.
Yes sir.
The opposite
16 लाख
जज
सर ने डिसाइड किया था कि या तो 16 लाख दे दो इनको, नहीं तो अपना वो ट्रांसफर कर देंगे हम केस को। ये उन्होंने बोला था 6 तारीख को। सर 6 के बाद 14 की डेट लगी थी, फिर 14 से 22 हो गया था। सर
कहाँ पे?
सर इसी में ही कोर्ट नंबर 11 और आइटम नंबर 45।
Justice Karol and.
जज सर ने बोला
हम थे हमको याद है।
On earlier.
नहीं जज सर
Opposite party is here, my lord may hear him also. To what extent her statement is right?
No. We are not here to decide his statement or her statement.
Very well.
Either we allow the transfer petition or there is a settlement. If there is no settlement, we will simply decide the transfer petition. We will not go into what transpired in the mediation and her retraction subsequently. The fact of the matter is, as on date, she is not agreeing for a settlement.
Very well.
If she is not agreeing,
her prerogative, she may agree, she may not agree.
yes.
But Malas may ask my party to whether he is agreeable for settlement, he wishes to give something, or he doesn't wish to give.
Yes, Mr. शशांक
जी सर, लास्ट जो मीडिएशन हुआ था
हाँ
उसमें जो मीडिएशन वकील थे उन्होंने इनको क्लियरली पूछा था कि आप अपनी मर्जी से इस चीज के लिए सहमत हो कि आप कोई पैसा नहीं लेना चाहती, अगर आप चाहो तो आप टाइम ले सकते हो, अपने फैमिली मेंबर से बात कर सकते हो। इन्होंने क्लियरली वहां पे बोला था कि मैं सोच समझ के डिसीजन ले रही हूँ और मेरा डिसीजन फाइनल है। कई बार इनको पूछा गया, इनको टाइम लेने के लिए कहा गया, उसके बाद इन्होंने खुद अपनी मर्जी से साइन किए थे और हमारे वकील थे, इनके वकील थे और मीडिएशन वाले वकील थे।
Witnesses are there.
और सर इन्होंने मुझे इतना
टाइम भी दिया
परेशान
गया।
किया। सर मैं आपको अपना दुख सुनाती हूँ सर। इन्होंने मुझे डिवोर्स देने के लिए मुझे गुड़गांव में छोड़ दिया, 1 रुपया भी नहीं सर। 4 साल हो गए। उसके बाद सर इन्होंने डिवोर्स डाला मुजफ्फरनगर में। मैं वहाँ पे मजदूरी टाइप की नौकरी करती हूँ सर। आप रिकॉर्ड है ना सर, तीसरे दिन की तारीख सर, पता नहीं कि 5 वकील साथ में होते थे और सब एक बोलता था, एक चुप होता था, एक बोलता था सर मेरे वकील अकेला, और उसको भी पैसे खिला के।
we are sorry for this mediator.
तीसरे दिन इन्होंने तारीख लगवाई, मुझे
Mediator
चूर कर दिया सर इन्होंने मुझे।
mediator has not properly informed the lady as to what is written in the settlement. There is nothing written in the settlement about the alimony.
The conscience was there in the proceedings.
और हमारे पास सर हमें सर ने बोला कि आप
Counsel for both the parties were there.
It simply says we will live separately, they will be divorced. How come this settlement will be recorded? No alimony, nothing, not a single penny.
She refuses to
Sorry. Although settlement has been recorded before the mediation center, but the said settlement does not record payment of alimony to the petitioner wife. In the above circumstances, we do not feel that the terms of settlement can be accepted upon the petitioner wife. With petitioner wife, which is a day for this court. Heard counsel for the party on transfer petition, transferred. Transfer petition.
Obliged.
Unless mandatorily required. Yes.
Letter
adjourned.
kindly refer it for second round of mediation. Kindly refer it to second round of mediation.
Which matter?
The 17th.
17th, there is a letter.
Yes, ma'am. There is a letter for seeking time to file counter affidavit, but we have instructions from the parties if it may be referred to.
No, where is the other party?
My lord, she has joined.
I am appearing for the petitioner. We are also willing. We can do the second round of mediation also.
Parties for the mediators. Mediator on on 7th May.
Obliged.
Thereafter, either physically, virtually, as directed by the mediator. Post on 3rd August for Submission of report, mediator center. Yes, next. 18.
One of the mediation is failed between the parties. I need a brief time to place my formal counter on the report.
Mediation has failed. Learned counsel for the respondent is and is allowed 2 weeks time to file complaint. 19. Yes.
We are appearing to some of the hospitals. Lordships had issued notice.
Replies have been, my lords, filed.
Yes.
Yes.
Replies have been filed?
Yes.
By all?
Yes.
All the hospital?
Yes.
Yes. Then a reply.
So, what's the reply?
Yes, who appears for this Arya Vaidyasalam?
Yes, ma'am. I appear.
Yes. What is your reply?
Yes. May I just tell you, Lordship, before Lordship see the reply, no?
Yes.
Now, this is an Ayurvedic hospital, as the name suggests, Lordship. Now, this is a charitable trust. There is no, at the outset, I'll say, there is no fault on our part. I'll tell you, Lordship, there was a problem. I'll tell you, Lordship, what the problem was. I won't run away from it. Earlier, there was a judgment directing 10% and 25% free treatment. Then there was a circular by the government of 2nd February 2012, which was a subsequent Supreme Court judgment said that has to be complied with. As per that circular now, we could, as a hospital, we could directly take people who comes as EWS. So at that time, we had no problem. Then what happened is, there was another circular which was 1st October 2025. Now, by that circular, the Delhi government said, you hospital, you cannot take anybody directly unless it's a casualty.
Unless it is.
Sorry, 31st December 25. 2020, sorry, my mistake. 31st December 2020, the Delhi government came up with a circular saying that you hospital, private hospitals, you can't take any EWS patient directly unless it's a casualty. Otherwise, it has been a referral from the government hospital. Now, we are an Ayurvedic hospital. Casualty by nature doesn't happen. Nobody comes to an Ayurvedic hospital with a casualty. They come for treatments. This referral, what happened is, once this referral became, the government started insisting referrals from government hospital, the number of patients who walk in has considerably reduced. Fortunately, now what has happened is, I think now the regime change or whatever, they have examined this, and there was a latest circular of 1st October 2025 by the Delhi government, which said anybody who comes with a food security card or ration card, you give them free treatment. So I produced figures. After that, there is a dramatic jump from October 25 to now after that, January, February, March, etc. We are complying with it. We are giving wide publicity to this. So this interregnum, the problem was that our inability of taking patients directly and insistence on a government referral, the number of IPD and OPD patients who come, they've considerably reduced. Now that problem is resolved because government itself, fortunately, has come up with a circular of 1st October 2025. After that, the figures are there in the reply. The figures have dramatically increased because of this, because now anybody can come to our hospital, come with a food security card, we look at it and we give them free treatment. So this was the regime earlier. In between, this insistence on referral, in my reply, I have mentioned the 2 circulars and the changes in the 2 circulars, especially for an Ayurvedic hospital, saying that you can only take without referral for casualty is of no use because casualty doesn't happen in Ayurvedic hospital. That happens in a allopathy hospital where emergency treatments are there. We don't do those kind of treatments. We have given wide publicity. I've annexed all those. Before I proceed further, Manoj,
This institute is by nature it's a charitable institute based in Kottakkal in Kerala. This is a pioneer of Ayurveda in India, this institute. In Kottakkal, we have a charitable hospital, 160-bed hospital, where we don't charge anything for any patient. Even in Delhi, there's a branch, there's a branch of the main hospital in Kerala. Even in this Delhi hospital, for outpatient, for anybody, whether it is however rich or poor you are, for consultation, we don't charge anything. Medicines we charge normally, but for EWS patients, even that is completely free. Now, at the outset, there has been no intention whatsoever to not give any treatment. There's a genuine difficulty with typical regime change. Regime 1, there was no problem. Regime 2, there was a problem. Now regime 3, after 1st October 2025, there's again no problem. Lordship sees that figures. November, December, January, November 25, December 25, January, February, March 26. We are complying. There is no problem. This is if now my request would have been to allow us to take directly. Now government itself fortunately has strengthened our hands by saying that forget this referent, you can take anybody who comes provided they give that ration card. We are doing this. Lordship may monitor us. Lordship may keep it pending. Monitor us for the next 6 months. See whether we are complying with. I can. On instructions, I say we don't. There's no shortage of patients who want free treatment. As Lordship knows, health sector, EWS patients, there is no. But the government has to make it simpler. Now they have made it simpler. So Lordship may monitor us for 6 months and see. We will comply. We have no utmost respect for the circulars and for Lordship directions. There is no intention whatsoever to run away from that. That undertaking Lordship may record. If the Lordship wants to monitor it, please monitor it. We will be complying. We are complying. But there has been a problem in the internet. I won't run away from that. There has been because of this issue. All this I've stated is in the reply. I can read it if your Lordship wants, but I've just summed up what is there in my reply.
Yes. Next hospital.
Yes.
Please, my lord. Next one. Second is Kailash Deepak. Who is for Kailash Deepak? Any council appearing for Kailash Deepak? Those who are not appearing in Kailash Deepak Hospital. Next, Rajan Fortis Hospital.
Yes, my lord, with my lord's permission, I am appearing from VC. And Lord, if a similar circular can be issued for us, we will comply because we are factually complying, but there is a, if I may say so, with great respect and all humility, a detailed bureaucratic process for referral through which only we can take in our inpatient in IPD, that is inpatient.
Have you filed reply?
Yes, I filed my reply. Yes, it's a reply, my lord.
Yes. Rajan.
That's
Rajan Fortis.
It is in MA, my lord's MA 1187, and it has been filed, my lord. The affidavit is of 23rd March 2026. And if your lordship kindly sees in the reply, we have given the details, my lord. Does my lord have the reply, my lord? I'm so sorry.
When you write to press, reply to it something.
So I got 24th of March 2020.
Yes. What we have said in the affidavit in reply, my lord.
Yes.
My lord has the copy now, my lord, or shall I say it orally, my lord? Whatever my lord permits.
Yes. In the meanwhile, yes.
Well, so what we have said is in para 3 that this honorable court appointed the secretary, my lord, Government of Health, Department of Health, NCT. In response, the notice was issued to us. We, my lords, pointed out that we are complying are taking all steps to comply with 25% OPD and 10% IPD. We also said, my lord, that there is a procedure which is there, and actually the way forward in the Ayurvedic hospital can be done in our case also, because we keep those beds vacant if we don't get enough referrals. And that is a problem, my lord. So I think that can be an excellent way forward on the basis of whatever card they specify. We can take, we of course have our whole, everything is on computer. And my lords, we can fill up the beds, but we don't use those beds for private paid patients at all. We leave them vacant. And again, my lord, I think my friend in the earlier case has fairly said, if need be, we can be monitored for the next 6 months to a year. If they can just tell us, my lord, a quicker way by which referrals take place. Kindly see here in para 9, page 4, with my lord's indulgence. EWS, that is economically weaker section patients, are either referred
Which
by...
page you are referring? Which page?
Page 4 of this affidavit of my lord, Flight Lieutenant Rajendran Hospital.
Page 4, para 9.
Para 9.
Yes.
EWS patients are either referred by the EWS cell of DGHS of the hospital or are direct walk-in patients. Every EWS patient who comes to the hospital either through the referral or direct walk-in is provided treatment. So this is, my lord, as far as the walk-in patients in OPD are concerned. It's humbly submitted that whenever hospital receives an EWS patient, either through referral mechanism or walk-in, the requirement to provide treatment has been complied with. The EWS OPD is functional on a daily basis. Hospital ensures all eligible patients are provided optimal medical treatment in accordance with the guidelines. Emergency EWS patients are attended to immediately and managed strictly as per the standard clinical protocols. All EWS IPD patients are duly attended to on a daily basis. All medicines are provided free of cost, and necessary investigation, laboratory, radiological, are conducted in a timely manner. Dialysis services are regularly made available. All facilities available within the hospital's premises are extended. I'm sorry. Yes. Where is the bit about IPD? They can start. May I, my lord?
Yes.
I'm so sorry. Then, my lord, para 9, then para 10, I have set out the details of both EWS OPD and EWS admission IPD. Now, for IPD, my lord, I have dealt with from para 6 onwards at page 3.
No, but what is the percentage? This you are simply quoted the numbers.
Well, that your lordship finds in para 8.
What we say, at least 10%, na?
Yes, ma'am. 10% for IPD, 25% for OPD. So what
Yes.
I'm saying is, my lord, whoever has come for OPD, either through referral or through the card, he has been, my lord, straight away provided for. There is no report to the contrary. And, my lord, as far
your numbers have over the years have reduced. This OPD number, instead of being 25% throughout the period,
yes,
from 19,468, it has gone down to 7,400 in 2025.
my lord, I have kept the facilities.
And if you recollect, now if you correlate the timeline, 2018 is our order, main order.
Yes, my lord.
When it is widely publicized and this court wanted this mechanism to be under play.
Well, I entirely bow down, but I respectfully say
in that year,
there were 19,000.
Number of patients were 19,000.
Yes, But I say with great respect and humility, my lord,
Over the years, since we did not monitor it properly, by asking you for submission of annual report.
We have been submitting regularly on our own.
19,400 to 19,200. Then 2020 straightway 19,000 to 9,000.
My lord, I quite see that, but I say with great humility and great respect, my lord, that I have made a statement on affidavit and oath that whoever has come has been dealt with. If your lordship wants, we can give, great publicity has been given, it can be further given. There is no, and your lordships can put us on monitoring also at our cost. I have no difficulty. Plus, there are, of course, maybe larger number of hospitals. I don't know the reason for this, but I have factually stated that I have not turned back anyone at all. And there is no case, my lord, of anybody. Even in the notices to us have not said you have turned back people. We don't do that, my lord, because we have followed it. We are, my lord, it's a Fortis group. It's a very well recognized group, and this is the only business which we do. So, my lord, of course, there is a private sector element also to it. But not as far as this commitment is concerned, we honestly, to the best of our capacity, do it. If, my lord, there is anything else to be done, I am, my lord, more than willing to do it. Your lordships will also direct monitoring, so that I quite see what falls from my lord is that it has gone down. But, my lord, that is how the numbers are. And like as for IPD, I was suggesting if it be, because let us kindly see what we say in para 8 in my IPD. Para 8, the hospital maintains the requisite reserve capacity.
Hearing two of the hospitals now, the impression is that most of the hospitals are not complying.
With great respect, I say with great respect and all humility.
Who will believe that you are not finding patients?
No, Lord, I quite see that, Lord. I don't know why.
Hospitals come with this plea.
Lord,
We are open, but people are not coming.
Lord, may I say this?
Who will believe in this country that EWS patients are not coming and everybody is willing to pay?
I quite see that.
Being available.
I quite see that. Lord. I quite
poor patients in this country.
I quite see that.
Everybody is willing to pay. What is this?
I quite see that. Would your lordship straight away today, at my cost, direct a commissioner to be there? In the next week, everything will be known. I am taking that, making that request myself. And he can go in a plain clothes, sit there, any lawyer your lordship chooses, and he can then point out that before me, these people returned back.
This is a voluminous report or affidavit by each of the hospitals.
Yes.
We'll appoint some amicus.
Yes.
Compile.
And may I, as my lord's officer, because I may say so with great respect and
clear a chart and then let us know who is complying, who is not complying.
Absolutely, my lord. And may I say, as my lord's officer, we are extremely grateful that my lord is doing so. And may I make a request, if my lord doesn't find it amiss, that for IPD, there is actually a little problem which needs ironing out. Namely, my lord, it is based only on referrals. So the government can examine it and say that it may be referral plus certain card. Because today everything is computerized. So the moment somebody comes with a relevant card, I can find out it's relevant. And straight away, my lord, admit it. Because we are leaving beds vacant, which, as my lord rightly says, in a country like India, is not a good thing. So I'm extremely grateful, my lord, from what falls from my lord. And I'm absolutely at one with my lord on this.
You are saying?
Yes.
We will consider.
Grateful.
Whether we should direct the government to refer. Well, it's referrals are not.
It's a referral procedure. I'm not saying that.
The plea is coming so that the government is referred, so that in the next monitoring process they will say, what can we do? Government is not sending us patients.
No. There is a referral process. I have said on oath. I
understand whatever you are submitting.
Very.
We understand. We fully understand.
Deeply obliged. Deeply.
pursuant to our order dated 24/2/2026, seeking compliance affidavit from the hospitals enlisted in para 6 of our order, such affidavits have been filed by several of the hospitals. Post para. Considering the detailed affidavit filed by the hospitals, we appoint so and so as amicus curiae to compile and prepare a chart of the on basis the compliance affidavit filed by the hospitals. The amicus shall submit a report before 3 days before the next date of review.
Hospitals who have not filed the response, some of them have still not filed the response. It's indicated in the office.
Therefore, we have not said that all the hospitals, we have several hospitals, we have forced the matter on 13th May.
A copy of that report will be given to the lawyers who are.
A copy of the report will be supplied to the councils representing the hospitals enlisted in our order dated so and so. Grateful. So those who are yet to file compliance affidavit may submit the same before the next date of hearing.
Much grateful.
Yes,
my lord. I had filed an IA intervening application in for that particular.
In which matter?
In Moolchand Union of India versus Moolchand Kharati.
You are appearing for?
My lords, I am appearing an applicant as in person. I am appearing as applicant in person, my lord. My lord,
which applicant?
My lord, I am praying for allowing my intervener allow me to.
Who are you?
I had filed a writ in the High Court, my lords.
Sorry.
Against my lord.
Sorry, no.
My lords, against the Rajiv Gandhi Cancer Hospital, my lords, I have the whole record from 1990 to 2020.
Rejected, implement rejected. Implement rejected. वो intervention application file किया इसमें 19.
In 19, I have small request just for inspection. Could you keep it at 2 p.m. on that day? Because it's impossible to even get into the court for 51 hospitals, so many lawyers. Because if 2 p.m. is possible.
We'll see to it that you are which serial number in that?
39 out of
39. We will see that we continue to take up the matter at whatever time it starts. That we reach only to till number 38 at 1 p.m.
Not only for me, Manoj.
Yes.
For everybody.
Yes.
In fact, there's difficulty with all of us being pushed around heavily just now.
We can't make the room bigger.
Grateful.
That is your difficulty. That is not our difficulty. We don't have solution for the space in this court. Don't make such prayers. That courtroom is big. What can we do? Courtroom is small.
Stamped just now, so it's just a
If you are being pushed, tell some other. This is not the place. What is this?
The Lordship, Mr. Gopal also gave this.
Mr. Gopal or Mr. Syam, we do not know. If the courtroom is not big enough, what can we do? Where do we find the solution? That since courtroom is small.
Take it in breaks, that's all.
Sorry, rejected your prayer.
Fine.
Rejected. You have understood. We are calling it one by one. There is a list of hospitals in our order. We started calling one by one so that there is no chaos. You wait outside. If your item is serial number 20, you keep a watch which number is going on. The matter, serial number 19, hospital comes, you walk in. Why should you be here or nothing? Yes. And you are doing it every day. It is not that only in this matter the courtroom is packed. Go to that CB or some other interesting matter. Yes.
May it please you, my lords, because I am done largely. I have a little bit to add only. Your lordship has seen STC, so I'm not repeating it. Lordship will just connect with the last time. My lords will notes will connect it.
Yes, yes, yes. Whereas page 35 of STC you were referring.
That your lordship is done with this because STC broadly your lordship has seen. That's your lordship ended. I will only suggest that your lordships, I've given the references of the Hidayatullah, who went into some detail. And then the conclusions are at 41, 42.
This STC?
Yes. Which are need not be read, your lordship will just note that bottom page. What is this page? This one. 41 of the PDF. At the very end. The whole judgment has the entire jurisprudence summarized by Justice Hidayatullah. It's a useful summary, but I'm not troubling the lordship with all that.
41?
Yeah. Is it 41? Will you tell the page? With all this. This is not the way to assist. Well, is this SCC online page I am referring to is
page 41.
Give me a minute. I don't know why you're here. This, where is this page? You've not even pages here. The beauty.
Page 39.
Where is page 39 bottom? We're here to assist you. Keep it here. At the bottom, just keep it here. I am therefore of the opinion that the State Trading Corporation cannot be regarded as a citizen for the purpose of enforcing rights under Article 19(1) F and G. The last line. Going on to the next page.
41.
Yes. No, it's 39 bottom. Your lordship printed page on top is 39. I mean the typed page or printed page.
Yes.
Last line.
I am therefore of the opinion.
Yes, yes. And then was okay, keep doing this. Then was this is followed by a constitution bench in Telpo. And for that, your lordship will turn to do this. This was
73, page 73.
Yes. Mr. Sibal read 85 and 86. I want to read, I'm not going to repeat scrupulously anything. I'm going to read the previous page. Printed page 84. On the top center page 84. It's also constitution bench. Well, the STC is a very respectable lineage. And therefore, well, it has been followed in several cases. I'm just showing some of the major ones which follows it on this point.
Yes. Which page you are referring?
84 is the printed page. 84. Why are you saying that? Just keep it like that. That being the position, does my lord have it?
Yes, yes, yes.
That being the position with regard to the doctrine of the veil of a corporation, the principle the said veil can be lifted in some cases. The question arises for our decision is, can we lift the veil of the petitioner and say that it is the shareholders who are really moving the court under 32, and so the existence of the legal and juristic separate entity of the petitioner as a corporation or as a company should not make the petitions filed by them under 32 incompetent. We do not think we can answer this question in the affirmative, but there's a double negative there. They are saying it can't be maintained. In a simple language, the triple negative in fact. No doubt the complaint made by the petitioners is that the fundamental rights are infringed. And it is a truism to say that the court, as the guardian of fundamental rights, the citizens will always attempt to safeguard the said fundamental rights. Having regard to the decision of this court in State Trading Corporation. Alon has got it?
Yes.
We do not see how we can legitimately entertain the petitioner's plea in the present petition, because if their plea is upheld, it would really mean that the cooperation of the companies cannot achieve directly, can be achieved by them indirectly by relying upon the doctrine of lifting of the veil. So you can't maintain a petition otherwise, but you lift the veil and say it's nothing but the government. If the corporations and companies are not citizens, it means that the Constitution intended that they should not get the benefit of 19. It is no doubt suggested by the petitioner, though Article 19 is confined to citizens, the Constitution makers may have thought. It is no doubt suggested by the petitioner. One of the petitioners said, please hold it maintainable. So they are dealing with that argument. It is no doubt suggested by the petitioners that though Article 19 is confined to citizens, the Constitution makers may have thought that in dealing with the claims of corporations to invoke the provisions of 19, courts would act upon the doctrine of lifting the veil and would not treat the attempts of the corporations on their behalf as falling outside 19. We do not think this argument is well founded. The effect of confining 19 to citizens as distinguished from persons to whom other articles like 14 apply clearly must be that it is only citizens to whom the rights under 19 are guaranteed. If the legislature intends that the benefit of 19 should be made available to the corporations, not be difficult for it to adopt a proper measure in their behalf by enlarging the definition of citizens prescribed by the Citizenship Act passed by Parliament. On the other hand, the fact that Parliament has not chosen to make any such provision indicates that it was not the intention of Parliament to treat corporations as citizens. Therefore, it seems to us the view of the District Court in the case of STC. The petitioners cannot be heard to say that the shareholders should be allowed to file the present petition on the ground that in substance, the corporations are nothing more than associations of shareholders. Whereas the next para has been read. It's important. Just underline where Lordship should read and I will not read because it has been read at the bottom of this page, below that judgment of All India Banks Industry. That's also important, and that I will treat as having been read to save time. Then, this is followed by yet another constitution bench at page 88. The third constitution bench. British India Steamship. Only one passage at 91. Starts in it is short judgment. Besides, it appears at 91 that these writs purport to raise a question about validity of 52A of the Sea Customs Act may have weighed in favor of equity in the matters. But as we have held in Civil Appeal 770, the foreign companies whose vessels have contravened the 52A, on which penalties have been imposed, are not entitled to claim the fundamental right. Now, this is true, it's a foreign issue. But I'm just saying on maintainability, citizens alone, not foreign, not corporations, not departments. In regard to the shipping costs, there are two categories. The previous para was foreign. This is now in regard to the shipping corporation, which was filed 3 writs. The said corporation is in no better position. As a result of the decision in STC, the shipping corporation cannot claim to be, etc., citizen not entitled to Article 9. Whereas Barium, a case which is very celebrated at page 92, is celebrated for the other point my Lord knows well, relevant considerations, irrelevant considerations, etc. But there is in that celebrated case a para on STC also at 103. It is not cited for that purpose so much, but it is at 103. As already stated, the appellant had challenged the provisions of two. I'm sorry, I'm very sorry.
Just 1 minute.
I'm sorry. As already stated, the appellant had challenged the provisions of 237. That is one of the inquiry by the inspector on which your Lordship had the famous laying down of law, etc. That was the old law.
Yes.
Sorry, my Lord, it starts at 103 and 103. Mr. Anjari has got it?
Yes.
As already stated, the appellant had challenged the provisions of 237 on the grounds that they are violating of the fundamental rights under 14 and 19. Our brother Shellett has dealt with this attack in the provisions fully, and we agree with him generally with what he has said while dealing with the contention. However, I'd like to add, the company being an artificial legal person cannot, as held by STC, claim the benefit of the provision of 19(1)(g). It applies to department equally. Through appellant 2. We agree with our learned brother that the action proposed under so-and-so being really exploratory, the fundamental rights to carry on with this, that's a separate issue. That's a separate issue. Now, let's, 2 more things and I'm done. One is, that the STC line of cases I'm just calling it the line. It's a very respectable lineage. Justice Hidayatullah, which is the main juristically elaborate judgment, makes it clear that they are not entitled to, the corporations or departments are not entitled, I'm summarizing this, the rights of natural persons who must be citizens. Now, Articles 21, 22, and 14 have been invoked by ED. I'm just summarizing. The Lordship knows this point, but no doubt invoked. Either ED has a 14, 21, 22, which even they don't contend. I am ED, this is ED. ED itself can't contend, I have 14, 21, 22 on this. The second contention is I am the officer of ED and I have that other officer petition. It is clear, and this is important. You cannot do indirectly what you can't do directly. Now that officer petition is nothing but nothing at all. That officer has no existence, no identity, no nothing except as a person discharging the duties under the statute, is my humble submission to my Lord. He is acting as a person discharging his statutory duties. In that, he is representing, acting for, in accordance with or not in accordance with a different question, the statutory provisions. So that's my answer to that petition.
Directly, indirectly principle.
Yes.
Whether it applies to administrative law or it applies to for maintaining a petition for breach of fundamental right also.
Yes. I'm very grateful for the query.
Yes.
Well, my humble submission applies to both.
Yes.
This principle of what you cannot do directly, you cannot do indirectly, is what I might submit, is only well as your Lordship is to consider making a submission, is a subject neutral principle. It's a subject neutral principle. So, if this cannot be done by this path, if I am able to show, obviously I have to show that, otherwise it won't work, that the alternative path is nothing but a camouflaged version of the same path, then your Lordship will apply the principle, subject neutral. Public law, private law, this is a principle of equity. Well, for example, your Lordship has another principle of equity, cannot take advantage of own wrong. I'm just giving an example. There is a judgment called Priyanka, which very deep. Third principle, you cannot say X and directly in the next sentence or the next paragraph or the next case before the same bench say Y, the opposite. These principles, very important query from my Lord Mishra, I'm answering this to the best of my ability, apply subject neutral. They don't apply in administrative law, disapply in contract, reapply in tort, and then again not apply in constitutional law. These are equitable principles meant for safeguarding the court itself.
Neutral and rights neutral also.
It's new across, absolutely. I mean, I cannot make a selective. If it applies, obviously, factual inquiry that the judge makes, whether it applies or not, is the judge's prerogative. Your Lordship may say, this path A is not a camouflage to B. That's the answer on facts. But the moment your Lordship comes to a finding that substantively the attempt is to reach the same goal by a camouflage, by an embellishment, by something or the other, we all know that, then my answer can't be selected. To my Lord's straight answer, the question, the answer has to be straight. That it will apply across. You call it rights, you call it liabilities, you call it duties, you call it subject. It has to be. Otherwise, your Lordships, these are self-protective, equitable principles. For example, the government says, you do this. I do this. And the government then penalizes. Taking advantage of your own wrong. Another principle, law cannot compel me to do the impossible. Department X says do this. Department Y penalizes me for doing that. Etc. etc. These are, your Lordship rightly puts it, rights neutral, subject neutral, principle neutral, case neutral, if they apply, if they arise. Now, therefore, this is and also lastly, they raise 14. So 21, 22 I've dealt with. ED raises 14 also. 14, arbitrariness and inequality neither arises for either the officer acting in the discharge of his duties nor for the department. That's simple. 14 is either the classification doctrine of equality or the doctrine of some arbitrariness. Now, of course, the Lordship has gone in those Joseph Stein and all those cases into substantive due process, etc. Maybe. None of them arise for an ED department or for an officer in this case. Then, there is one case very old venerated case, which I want to, it's really one of the first, those Article 14 cases, Part 3 cases. That's Charanjit at page 537. Is it printed 537? Same volume? Your Lordship, same volume, 537. Please come with it. Very nice to know that 1950 is now supplied by SCC.
Yes.
Lordship will never get this title on any case. You'll always look at SCRs or AIR.
But the only difficulty is paragraphs are missing.
That's true. That's true. That will change. Charanjit was actually the first case after the functioning of the Republic was of a major kind in terms of this article. This was the doctrine of classification, is known for that.
Yes.
Now, if your Lordship comes to para 13, which is at 563, I'm only reading some portions for my point, because I'm not going to the. It's a very detailed judgment, because those days the law was not developed. Article 14 is literally a baby. The application, I'm interested from placitum B.
563.
Yes, the relevant part, para 13. I'm interested from placitum above placitum B, but I will read the whole para for completeness.
Yes.
The application before us under 32 is on behalf of an individual shareholder of the company. 32, as its provision show, is not directly concerned with determination of constitutional validity of particular enactments. What it aims at is the enforcing of fundamental rights guaranteed by the Constitution, no matter whether the necessity for such enforcement arises out of an action of the executive or the legislature. Now, this is the part the Lordship may consider emphasizing as far as I am concerned. To make out a case under this article, it is incumbent upon the petitioner to establish not merely that the law complained of is beyond the competence of the particular legislature as not being covered. So that's the legislative competence test, the noun validity. But that it affects or invades his, mark the word his, fundamental rights guaranteed. That's the word his, of which he, again he, could seek enforcement in an appropriate way. The rights that could be enforced under 32 must ordinarily be the rights of the petitioner himself. Well, one exception is PIL. Lordship has everything. It's not that a Lordship is without any remedy or without power. The Lordship is fashioned PIL. When a Lordship wants some particular jurisdiction, Lordship has that jurisdiction. Rights of the petitioner himself, who complains of infraction of such rights and approaches the court for relief. This being the position, the proper subject of our investigation would be what rights, if any, of the petitioner as a shareholder have been violated by the improved legislation. We are far away from this. He is talking about shareholder rights. We are talking about department's rights. Well, Justice Fazal Ali, this is Justice Mukherjee and Justice Kania, authored by Justice Mukherjee. Justice Fazal Ali in para 52, page 574, says this: the directness and the personalized nature are emphasized by Constitution Bench in the first year of our Republic. The directness and the personal nature are the two aspects I'm emphasizing. And this is held good for 75-80 years now, para 52. It has been held in a number of cases in the United States of America that no one except those whose rights are directly affected by a law can raise the question of constitutionality of that law. This principle has been very clearly stated. It is an elementary principle that in order to justify the granting of this extraordinary relief, the complainant's need of it in the absence of an adequate remedy must clearly appear. Complainant cannot succeed merely because someone else may be hurt. Only exception PI. My Lord stated it. Same law otherwise here, up until now. Nor does it make any difference that other persons who may be injured are persons of the same race or occupation. On that statement of law, which I entirely agree, the scope of the discussion is greatly restricted. Justice Fazali says that. Justice S.R. Das speaks at page 595 at para 120. Fourth line, I read the whole. I read the second sentence on this. Third line. My Lord has got below. 595 is page, 120 is para. Third line, your Lord should turn to. After the 14th Amendment, etc. If such be the requirements of law in connection with the Equal Protection Clause, which corresponds to our Article 14, it appears to me to follow that only a person who's the owner of the property can raise the question of constitutionality under so and so of a law of which he is so deprived. If direct interest is necessary to permit a person to raise the question of constitutionality under 14, a direct interest in the property will, I apprehend, be necessary to entitle a person to challenge a law. So two things, Malas. Himself, identity, and directness of interest. They both fuse. Then, Malas, may I try and conclude now? Let's just summarize my principles. You should have seen enough law, Malas, here and there with the citing law. So my solutions are, Malas, A, I'm just giving Malas points if you doesn't mind. ED has no fundamental right to investigate. We're looking from all angles. So one is, I have a fundamental right under Part 3 to investigate. Sorry, no. No such fundamental right has been created by our lordships in any form, in any manner, at any time. Second, its office, so first is ED has no fundamental right to investigate. Second, its officers have no fundamental right to investigate. Yes. Three, there is no claim of a representative capacity which can arise because you are governed by statute, especially section 8(6) and 8(8) of the PMLA. This is not some kind of a civil action where order one rule 8 principle will apply. It's a criminal action, investigation, no question. Fourth, ED officer theoretically as a human being can have a 21 right. I'm not saying that you are, well, suppose the ED officer, not in the discharge of his statutory duty, is driving along and somebody starts beating him up, state action. Nobody is saying doesn't have a fundamental right. But an ED officer acting as an officer in a this investigation, investigating her, cannot claim a separate right at which my department doesn't have the right. The statute doesn't have a right, but I have a right. That's the point I make. So don't misunderstand me. I'm not suggesting the human being can't have a right in a hypothetical case. Then, these are 4 points. Fifth point. Parents patrie, a completely erroneous principle pressed into service. Completely and thoroughly erroneous in a criminal investigation involving Part 3 issues. Will apply only when the affected party comes through some kind of a marginalized or deprived situation. ED can hardly claim the protection of parents. It is itself the parents' patrie. As a matter of fact, there is no greater authority today in the country except ED. How can ED claim somebody else's parents' patrie? I will make an aside. Don't misunderstand me. Aside. We were discussing the other day in court also that how is it possible that sensible people are having this digital arrest? I'm not talking of case X or Y. It is incredible. Yes. People we know who are otherwise normal people, who are retired management consultants, US returned senior citizens, are under digital arrest for 5 days, for 5 weeks. Which means, the wife doesn't talk to the husband doesn't talk to the wife, and they don't go out socially. This is your lordship is read in the paper every day. So, I said jokingly, it is 90% cases because of terror of the caller who only cites one authority. Your lordship knows the telephone call doesn't cite the younger brother.
But that's not true. I'm sorry, there are maximum cases of local police.
No, very well.
Maximum cases.
Very well.
That's not my example. Political.
Very well. Political platform or not.
Yes.
We also read newspapers.
Fake uniform of a local
There is a vast difference between the terror created by the local police and when the caller says ED, and we know it. We read every day.
So in this case, who was under digital?
I said parents' patrie. I started by saying, don't bother. Parents' patrie is the last refuge to an authority like the EDs all the time say. They are considered the parents' patrie, the big boss.
There can be several parents.
Of course. That's all. I'm not suggesting in this case.
I spoke about who in this case is the parent.
Very well, very well. Well, your lordship is discussing maintainability at the moment. It's not your lordship is. And then, Lastly, last point. What are your prayer? You have seen the prayer many times. Prayer to CBIs to investigate. Well, where is the fundamental right for an authority like the ED asking the CBI that under my exercise of a fundamental right as a person, I can ask you, the court, to please direct the CBI to investigate? That's very far-fetched. With great respect. So those are my submissions. Very deeply obliged for the accommodation. I took time in between because I was on legs. I'm deeply obliged.
In a matter like this, it happens.
Deeply obliged.
We have to accommodate.
Grateful manage. Excuse my absence now.
I'll be, yeah, I'll be doing I'll be going next.
Who appears for whom? Lord, it may not happen that one party is represented by two.
I don't know for DGP. I said so last time when you objected.
I'm not objecting to
I appeared for DGP.
because Mr. Sibal argued.
No, we have noted you appear.
Everyone argued. I don't mind not anybody. Nothing would be ended. But
He is not the gatekeeper of.
I think the part of the problem arose because the
anyway,
he did not realize he made a lot
Bengal
of
here.
he made a lot of respondents.
I appeared for the smallest. I appeared for the smallest. I appeared for the DCP. So I was
Anyway, they are arguing. I'm not there arguing. I'm only on the question of wasting time. Two people arguing for the same client may waste time. That's all.
We have made lots of respondents. I'm sure we are entitled to present our case.
But I think what my learned friend the solicitor with his usual generosity will allow us to start. With his usual generosity.
Now, may it please my lords. My lords, on the issue of maintainability, and I'll start with that before I hand over my propositions, my lords. I think it's only fitting, my lords, that when the lordships that when
You are waiting for?
I appear for R2, my lords.
In which petition?
My lords, in the main petition. Main petition. Now, before I hand over my propositions, my lord, your lordships are confronted with a seminal case which tests the efficacy of a citizen alleging violation of Part 3 rights. And I say that because within the Constituent Assembly,
There appears to be a mistake because Mr. Sibal appeared for R2, if I'm not mistaken.
my lords, I'm sure we can have two people appear for R2. The state is also there.
But it is not proper. Two people can, two for council cannot argue for
My
this.
lords, the state is also
Otherwise,
there.
if two is permissible, three is also permissible.
The state is there. The Commissioner of Police is there. We are making arguments on maintainability.
You cannot start arguing and then choose your client for whom you will be arguing.
Mr. Kalyan, that is also
State.
maybe there's a mistake. All of
Well,
this is a mistake.
Under the Supreme Court rules, two counsel can appear for party. Under the rules of the Supreme Court. Be that as it
Here and argue also.
yes, but
Where is the rule? Let us see. Let's see the rule.
my lords, there is also the state of West Bengal. There is also the Commissioner of Police, my lords, who has not appeared.
No, if this is the rule, we can allow. In a given case,
You can divide the.
we see in a given case,
The rule is there, which
which
shows
parties want to finish, but we don't want to get finished. We will allow many.
we want to be able to argue before your lordships. The Commissioner of Police has also not appeared. And your lordships, I know, would want to hear arguments on such a significant issue in constitutional law. I'm not on the politics of anything.
Yes, yes, you argue, please. Please.
But can I take permission, come back in Dubai? Can I come back Lord?
Yes, yes, come back.
Okay, that's just
And
permission.
tell her not to finish and before you come back.
But I'm sure your lordship, we asking questions will keep her occupied.
Yes.
I'll be back.
Yeah, may I just,
Yes.
my lords, I want to start where perhaps all conversations on the Constitution should start, in the debates, if you will, my lords, in the debates of the So may I just hand over, my lords, the Constituent Assembly debates Thursday, 9th December 1948. My lord,
But on a lighter note, before she starts, whenever the respondents try their best, even starting from pre-independence, that reject it at the threshold, don't go into the facts of the case, is a first and foremost evidence that facts are really troubling.
surprised that the
Yes.
solicitor.
Yes.
We will not
I'm
stop you,
surprised.
like we are not stopping you.
Yes,
We will not stop
surprised
you
the
also.
solicitor
No, we will not. We
You
will
proceed
be
in your
confined, my lord.
problems with the
It's not-
constituent debates.
You
being
proceed in
referred
your own way.
I'll
And place
we will
all
be
the-
brief.
all
We
the
will be
facts.
brief. We know, my lord, what are the contours of the matter. We are not, my lord, we are addressing only a lordship.
No, we are not saying.
The solicitor seems very skeptical of the
What we are
constituent
saying
debates,
is
my
that if the facts are, you see, so vivid, you please tell us the facts also. Yes.
Yes, may I, my lords? Your lordships will please see, my lords. This is the constituent debates, 9th December. 9th December 1948. My lords may please go to my lords. This is the Honorable Dr. B.R. Ambedkar discussing what would become Article 32 of the Constitution.
Yes.
Yes, my lords. Your lordships will see this will be page 1, 2, 3, 4, 5, 6, my lords. The 6th page. It says so, my lords, right on top. The Honorable Dr. B.R. Ambedkar. Yes, the words, directions, and orders are there. My lords have that.
Yes. Page 33.
Page 33. Yes, ma'am. Page 33, right on top.
Yes.
My lords has that? Yes. My lords, may I just take you to the last paragraph on the page? And what is being discussed in 1948 as the country confronts partition, the lordships are aware. And the constitution is being crafted by the Constituent Assembly. And we start in cases like this when we're trying to interpret the intention and the cause of a textual provision of the Constitution by grounding it in what inspired its formulation. Please see. My lords has the last paragraph.
Yes.
Yes. My friend Mr. Sarvati said that while exercising the powers given under this article, and this is article what would become Article 32, my lords, the court should have the freedom to enter into the facts of the case. I have no doubt about it that Mr. Sarvati has misunderstood the scope and nature of these writs. I therefore think that I need make no apology for explaining the nature of these writs. These are the 5 writs under Article 32. Anyone who knows anything about English law will realize and understand that the writs which are being referred to in the article fall into 2 categories. They are called in one sense prerogative writs. In another sense, other case, they are called writs in action. A writ of mandamus, a writ of prohibition, a writ of certiorari can be used or applied for both. It can be used as a prerogative writ, or it may be applied for by a litigant in the course of a suit or proceedings. The importance of these writs, which are given by this article, lies in the fact that they are prerogative writs, that they can be sought for by an aggrieved party without bringing any proceedings or suit. Ordinarily, you must first file a suit before you can get any kind of order from the court, whether the order is of the nature of mandamus, prohibition, or certiorari, or anything of the kind. But here, so far as this article is concerned, without filing any proceedings, you can straight away go to the court and apply for the writ. Page of comments. The object of the writ is to grant what I may call interim relief. For instance, if a man is arrested without filing a suit or a proceeding against the officer who arrests him, he can file a petition to the court for setting him at liberty. It is not necessary for him to first file a suit or a proceeding against the officer. Now, if your lordship skip 3 lines and come to all that the court can inquire in a habeas corpus proceeding is whether the arrest is lawful and will not enter into the question, at least that is the practice of the court, of the merits of the law. When a person is actually arrested and his trial has commenced, it is in the course of those proceedings that the court would be entitled to go into the facts and to come to a decision whether a particular law in which a person
Yes, yes, please.
All that the court can inquire, my lords, in a habeas corpus proceeding is whether the arrest is lawful, will not enter into the question, at least that is the practice of the court, of the merits of the law. When a person is actually arrested and his trial has commenced, it is in the course of those proceedings that the court would be entitled to go into the facts and to come to a decision whether a particular law under which a person is arrested is a good law or a bad law. Then the court will go into the question whether it conflicts with the provisions of the Constitution. Consequently, the amendment moved by my friend Shri V.S. Sarvate, if I may say so, is quite out of place. It is not here that such a provision can be made. If he refers to Article 115, he will find that a provision for similar writs have been made there. But those are the writs which can be issued in connection with questions of fact and law. They would certainly be investigated by the courts. Now, so I'm very glad that the majority of those who spoke on this article have realized the importance and significance of this article. And this is important, my lords, and your lordships may mark this. If I was asked to name any particular article in this constitution as the most important, an article without which this constitution would be a nullity, I could not refer to any other article except this one. It is the very soul of the Constitution and the very heart of it. And I am glad that the House has realized its importance. There is, however, one thing which I find that the members who spoke on this have not sufficiently realized. It is to this fact that I advert before I take my seat. These writs to which reference is made in this article, in a sense, not new. Habeas corpus exists in our Criminal Procedure Code. The writ of mandamus finds a place in our law of specific relief, and certain other writs which are referred to here are also mentioned in various laws. But there is a difference between the situation as it exists with regard to these writs and the situation as will now arise after the passing of this consultation. The writs which exist now in our various laws are at the mercy of the legislature. Our Criminal Procedure Code, which contains a provision with regard to habeas corpus, can be amended by the existing legislature. Our Specific Relief Act also can be amended, and the writ of habeas corpus and the right of mandamus can be taken away without any difficulty whatsoever by a legislature which happens to have a majority, and the majority happens to be a single-minded majority. Hereafter, it would not be possible for any legislature to take away the writs which are mentioned in this article. It is not that the Supreme Court is left to be invested with the power to issue these writs by a law to be made by the legislature as its sweet will. The Constitution has invested the Supreme Court with these rights, and these rights could not be taken away unless and until the Constitution itself is amended by means left open to the legislature. This, in my judgment, and this may be marked, my lords, this, in my judgment, is one of the greatest safeguards that can be provided for the safety and security of the individual. Your lordships will see this. The safety and security of the individual. We need not therefore have much apprehension that the freedoms which this Constitution has provided will be taken away by any legislature merely because it happens to have a majority. And my lords, then there is a discussion here about directive principles and fundamental rights. Your lordships will see, and there is a comparative conversation. So your lordship will see that this part is particularly clarifying. It's illuminating as to who and what was intended to be the beneficiary of Article 32 rights. It is an individual or a citizen who is looking to enforce her fundamental rights against whom? Against the state. Now, your lordships will see, my lords, and I'll in a little bit hand over specific propositions. But before I do that, may I just take you, my lords, to the Government of India Act 1935. My lords, may I have a sip of water? Thank you.
Right.
They don't need it. And we'll give a list of all the documents and readings handed over, my lords. We'll make it simple and we'll file it also eventually at the end of submissions, my lords. When your lordships has reserved judgment, we'll file the submissions, we'll file all the documents, my lords, neatly in neat compilations.
Yes.
Yes. Now, your lordships will see the Government of India Act 1935. I have not printed out all 343 pages of it. I have only printed the arrangement of sections. Your lordships will see, and this is the act that the nationalist movement called the slave constitution. Because you can have constitutions, and within those constitutions, you can be enslaved. Now, if you will see the big difference between the arrangement of sections part of the Government of India Act 1935 and the Constitution of India 1950, perhaps the biggest difference, even though there are a number of similarities, the biggest difference is what Dr. Ambedkar called the very soul of the Constitution, Part 3. And the enforcement mechanism of that soul, which is Article 32. So, therefore, the context which Dr. Ambedkar discusses in the passages I read to you, that why is it that you have Article 32? It is so that even if you have legislatures in majority, even if you have political parties in majority, you will have this part and this trigger. This is the trigger for the citizen in constitutional India to be able to enforce her fundamental rights and nothing else. That is the intended prescription by the drafters of India's constitution of Article 32. And therein lies the big difference. That is the constitutional revolution that was brought in by the drafters of our Constitution 1950 as compared to the Government of India Act 1935. Now, if your lordships find that the officers of the enforcement directorates can move an Article 32 petition before your lordships as officers of the enforcement directorate, not as individuals and not as human beings, as Dr. Singhvi discussed, then your lordships are actually entertaining a situation which was not intended by the framers of India's constitution. Because the ability for interdepartmental issues within the state to be triggered by Article 32 weakens Part 3 for all citizens in this country. And that will be the legacy of an argument like this. Now, your lordships, may I just take you, my lords, to Part 3. Where are the propositions? May I just hand these over, my lords? Now, what is the nature, my lords, of Part 3 rights? And from this, I'll take your lordships to Keshavananda and then hand over the propositions. If your lordship sees the scheme of all of these Part 3 rights, 14, 15, 16, 17, 18, 19, all of them, my lords, are actions pertaining to the state. 14. The state shall not deny to any person equality before the law or equal protection of the law. 15. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth. 16. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. 17. 18. Abolition of titles. No title not being a military or academic distinction shall be conferred by the state. There is nothing in Part 3, and I can read every article to you. There is nothing in Part 3 which is intended to enable interdepartmental warfare or the state to trigger a Part 3 right as a victim and not a constitutional wrongdoer. That is unenvisaged by both the drafters of India's constitution and, my lords, most importantly, the text of India's constitution. The schematic arrangement of the text of India's constitution is that these are rights against the state. The state does not get to be the victim when triggering a 32 petition. And the text of Part 3 articles are very, very clear. Now, my lords, may I just hand over a list of propositions? May I just read them, my lords?
Yes.
I'm grateful, my lords. Article 32, I have 6 propositions, my lords. Article 32, the very soul of the Constitution, this is Dr. Ambedkar being quoted, as a remedy, can only be triggered of individuals by citizens for violation of their Part 3 rights. 2. The state cannot simultaneously occupy the position of a constitutional wrongdoer and a victim. 3. The writs under Article 32, envisaged as remedies for rights enforcement, illustrate the character of their usage against the state or courts. 4. The Supreme Court has in contemporary times reined in the Enforcement Directorate for overreach in the context of privacy, ownership of information, attorney-client privilege, search and seizure powers. And I'll take your lordships to recent decisions of the Supreme Court doing so. 5. The constitutionally appropriate party here, the union government, if in dispute with the state, ought to proceed under Article 131 of the Constitution. And 6. Questions relating to character of Article 32 writ jurisdiction, union state dispute, etc., qualify as substantial questions of law and hence trigger Article 145(3), mandating a reference to a larger constitution bench. So, your lordships will see, my lords, these are the 6 propositions that I will advance and seek to place before my lords. And these are on maintainability. Now, my lords, may I just hand over my second handout? This is Keshavananda Bharti versus State of Kerala. Abridged, my lords, not the entire decision. It's 2 specific pages, my lords, pages 165 and 167. Yes. My lords will see, my lords. I'd only trouble your lordships with pages 165 and 167. This is the majority, my lords, in Keshavananda. Justice Sikri, Shellath, Hegde, Grover, Mukherjee, Reddy, and Justice Khanna. Now, may I take you, my lords? 65. This is the second page. Bottom of the page, please.
Yes.
The trouble, my lords, with 2 pages. My lord sees this. The basic structure. This is the court, my lords, arriving at these conclusions. The basic structure, my lords, has that bottom of the page. May be said to consist of.
Yes.
Yes. My lords, may please mark this. The basic structure may be said to consist of the following features: supremacy of the Constitution, republican and democratic form of government, secular character of the Constitution, separation of powers between the legislature, the executive, and the judiciary, federal character of the Constitution. The above structure is built on the basic foundation of the dignity and freedom of the individual. This is of supreme importance. This cannot, by any form of amendment, be destroyed. So your lordships, my lords, will then come down to the next page, my lords, page 167. My lords has that 1 page over, my lords. This is Justice Sikri writing. And what is the context of this, my lords? The context of this is how do we understand fundamental rights? That is the context. My lords, 3rd paragraph, middle of the page. This is Anjaria has that. Thank you, lords. Various decisions of this court describe fundamental rights as natural rights or human rights. Some of these decisions are extracted below. And I'll quote, "There can be no doubt that the people of India have an exercise of their sovereign will, as expressed in the preamble, adopted the democratic ideal, which assures to the citizen the dignity of the individual and other cherished human values as a means to the full evolution and expression of his personality, and in delegating to the legislature, the executive, and the judiciary their respective powers in the Constitution, reserve to themselves certain fundamental rights, so called, I apprehend, because they have been retained by the people and made paramount to the delegated powers." Now, the point being, my lords, that there are certain natural rights that are inherent to citizens and individuals in this country. And those natural rights are captured in Part 3. And therefore, when those rights are being trampled by the state, you trigger Part 3 violations or fundamental rights violation. And therefore, for the state to argue that its Part 3 rights are being violated is not just unintended by the constitutional text, by the drafters of the Constitution, but also by the largest bench that this court has ever constituted in Keshavananda. Now, may I just take you, my lords, to page 817. My lords, at the bottom of the page, my lords. May I just take
Yes.
I have rights, your lordships will see
Yes.
the indented portion in quotes at the bottom of that page.
Yes.
My Lord Justice Anjaria has it 817, my lord. Sorry, 817.
Yes.
Yes. My lords, bottom of that page in italics. And this is what Justice Matthew is quoting in Keshava. "I have rights which are inherent in me as a member of society, and I judge the state as the fundamental instrument of society. by the manner in which it seeks to secure for me the substance of those rights. And my lords may please mark this, in which it seeks to secure for me the substance of my rights, of those rights. Rights in this sense are the groundwork of the state. They are the quality which gives to the exercise of its power a moral penumbra. And they are natural rights in the sense that they are necessary for a good life. So your lordships will see, my lords, that what the Constitution bench in Keshava is trying to do and make clear is that
This is something said by Harold Lasky.
Yes, my lord.
Which is quoted.
Yes, my lord. Which Justice Matthew is quoting, my lord. My lord. And he is discussing on page 817, the second paragraph. Despite these attacks, the ebb and flow of its fortune, there has been a revival in the law of nature in the 20th century. Lordships also, my lords, quote and speak to the political context of the moment, my lords. And in this case, Justice Matthew is doing that in the political context of that moment. But what binds us from this time to that time behind and to the framers' time is that we have a moral constitutional understanding. And that understanding is that Part 3 rights are natural rights. They are in the nature of what cannot be taken away. And when they are taken away from citizens, the citizens can trigger a 32 and come to your lordships, not the state. That is what is a thread that binds these three political times and moments of constitutional history. Now, my lords, I'll take your lordships to a case, Ujjam Bai versus State of UP, my lords. This is 1962 Supreme Court cases, SC8. And my lords, we'll give a list of all of these citations to make it easier, my lords. Paragraph 99, my lord. I'll trouble your lordships with one paragraph alone.
Yes.
Yes. Your lordship sees this, my lords. Paragraph 99 is on what is page 39, my lords, top of the page. Paragraph 99, my lord. My lords, we've just printed the top page.
Yes.
And this is Justice Subara's decision starting at, my lords, paragraph 94. And this is a conception, my lords. Fundamental rights, and I'll read it very briefly, my lords. Fundamental rights are enshrined in Part 3 of the Constitution as the paramount rights of the people. Article 13(2) prohibits the state from making any law which takes away or abridges the rights conferred by the part and declares that any law made in contravention of this clause shall, to the extent of the contravention, be void. These rights may be broadly stated to relate to rights of equality, rights of freedom. So equality, my lords, 14 to 18 is the chart I handed over. Rights to freedom, articles 19 to 22. The right against exploitation, articles 23 and 24. The right to freedom of religion, articles 25 to 28. Cultural and educational rights, article 29 and 30. Right to property, 31 and 31A. Right to constitutional remedies, articles 32 to 35. These are the inalienable rights of the people of this country, some of them of non-citizens also, for instance, 21, my lords, believed to be necessary for the development of the human personality. They are essential for working out one's way of life. In theory, these rights are reserved to the people after the delegation of other rights by them to the institutions of government created by the Constitution, which expresses their will. And you can see, my lords, below, see the observations of the great judge, my lords, Patanjali Shastri, as he then was, in A.K. Gopalan, State of Madras versus Srimati. And then again, the same principle is extracted there. Your lordships will see at the bottom of that page. I won't trouble my lords, but my lords may please just mark it. Yes. My lords, now may I take you, my lords, for a very lovely decision, my lords, Motilal versus the government of the state of Uttar Pradesh. 1915, SCC, online, Allahabad, 197. Yeah. Your lordship will see, my lords, this is a full bench, my lords. My lords has this on the top of the page, the full bench, my lords, Honorable Justice, Chief Justice Malik, Justice Mutam, Justice Banshu, Justice Sapru, and Justice Agarwal.
Yeah.
And the decision, my lords, pertains to the right of a user to the highway. Now, please see, my lords. And here, a writ of mandamus was sought. Now, please see, my lords. May I take both my lords to page 387. Bottom of the page, my lords. My lords has this second last paragraph. The insertion of fundamental rights in the Constitution is thus a deliberate departure from British concepts, and it is necessary to seek the reasons for it, particularly as they limit the sovereignty assigned to Parliament. My lords, may I just stop here for a second? This is a very big departure because the British Parliament is unchecked. Parliament is sovereign. Judicial review is constrained. In this country, all institutions are checked by the Constitution, including Parliament. The history of the evolution of thought on the rights of man takes us back into the 17th century or even earlier. From the time of Tom Paine's Rights of Man, Jefferson's Declaration of Rights, Rousseau and the French Revolution, schools of thoughts have existed, down to H.G. Wells and discussions on human rights, which assert that man has certain natural or inalienable rights, and it is the function of the state, in order that human liberty might be preserved and human personality developed, to give recognition and free play to those rights. Fundamental rights would practically be to be found in every constitution that came into existence after World War I. After World War II, as a result of the discussions on the proposed United Nations Charter of Human Rights, they have become even more visibly important in most constitutions framed after the war. So this understanding is a universal understanding today, your lordships, that fundamental rights which inhere in all citizens of each state after World War II cannot be trampled upon by the state, and it is the state that is being, it is the citizen that is being protected from the state. What the union here seeks to do is to try to undo this understanding. It is not just a 75-year-old understanding in constitutionally free India, but it is an understanding accepted the world over, especially, my lords, in post-colonial states that have suffered colonization. We know that our citizens must always be protected from the state, and therefore we have something like a Part 3. My lords, may I now take you to Mr. C. Banerjee. Now, may I take you to paragraph 7.4, page 350.
Yes.
Yes, my lord. My Lord Justice Anjaria has it, my lord. Yeah, I read, my lord. Thank you. By defining the state and law very widely, and this is Mr. Sirwai's understanding, my lords, and his book is still the authoritative book. It is actually an authoritative insight into the Constitution as opposed to a commentary, a case commentary. By defining the state and law very widely, the founding fathers ensured that fundamental rights operated over the widest field. The Declaration on Article 13(1) and 2, making laws inconsistent with or contrary to fundamental rights pro tanto void, would not by itself prevent the state from violating fundamental rights. To effectively prevent the state from violating fundamental rights, the founding fathers created a new fundamental right by enacting Article 32, which guaranteed the right to move the Supreme Court for the enforcement of fundamental rights. Article 32(2) armed the Supreme Court with power to issue appropriate writs, orders, or directions to prevent a violation of fundamental rights. Now, may I just take you, my lords? May I just take you to paragraph 16.84. 16.84, my lords, which is the last page, page 1493.
Yes.
Now, please see, my lords, and this is where Mr. Sirwai very nicely shows us the difference in our constitutional state and what was. And the union, what they're asking for, takes us back to that time, pre-constitutional India. Please see. Mandamus does not lie against the crown, 16.84. That there can be no mandamus to the sovereign, there can be no doubt, both because there would be an incongruity in the queen commanding herself to do an
Crown, are the respondents crown? I'm sorry, let her continue. This helps. Fortunately, we are in a democracy. Nobody is a crown.
Mandamus does not lie against the crown. Yes. That there can be no mandamus to the sovereign, there can be no doubt, both because there would be an incongruity in the queen commanding herself to do an act, and also because disobedience to a writ of mandamus is to be enforced by attachment.
Who is the queen here?
My lords, here the state is saying that it is the victim, and Mr. Siva is showing that this is a time distinct from there. That here, that was a time where writs did not lie. This is a time where writs lie against the state, which may be an elected government, but again is still the state. That's the point. If the solicitor had taken a copy of the handout, he may have seen that. But since he's chosen not to take any handouts, then who will explain, my lords? Now, my lords, may I just take you to the next part, my lords, which is that the state, my lords, cannot simultaneously. This is proposition 2 your lordships has on the list of propositions. 2 and 3, my lords, may just mark this, that the state cannot simultaneously occupy the position of a constitutional wrongdoer and a victim, and that the writs under Article 32 envisaged as remedies for rights enforcement illustrate the character of their usage against the state or courts. So against the state or courts, my lord. My lords, these are a table of the kinds of writs that are triggered by Article 32. No, sir. I don't want to read, you might tell you something. Now, my lords, may I just very briefly, I'm not going to read the whole thing, but very briefly. These are typically what are called the 5 prerogative writs that are issuable under Article 32. Please see the nature of the writs, my lords. Habeas corpus, mandamus, certiorari, prohibition, quo warranto. Now, habeas corpus, the first one, my lords. May I just read the first line?
Yes. Habeas corpus, yes.
A writ, my lord, should we continue after lunch, my lords? Would your lordship prefer that?
Yes.
Very well. So I'm so grateful.
Yeah, during the recess, my lord, we will also revive our knowledge of writs. We used to study this in first law. Very elementary.
It's still the law, my lord,
Yes.
fortunately. It's still the law.
Right.
With your lordship's permission, may I mention, the lordship's permission, may I mention item 28 which is listed today.
Letter
28 is circulated a letter for filing counter.
I have no difficulty. I may be permitted to file rejoinder within 2 weeks thereafter, my lord.
28, what is the matter?
This is a dealing matter. It's pertaining to
28.
land sales, urban lands.
Please.
28, madam. Who has circulated the letter?
That's the state of the respondents.
I have no state.
What do you want?
Because I'm wanting some time to file a counter, probably 2 weeks.
2 weeks for counter,
And 2 weeks thereafter, my
2
lord.
weeks thereafter for rejoinder.
Some date in May, maybe.
May not possible.
Somewhere in July.
Post on 23rd July.
Not sure.
Wait for the indulgence.
The serial number 25, you know, the serial number 25, if I could mention, could be taken up. Serial
Can be taken up. We are in the midst of hearing.
Then could it be adjourned, my lord, to
Adjourn.
23rd July? Or 22nd or 23rd, my lord, subject to your lordship's convenience?
No, what is the urgency?
Well, the after notice, my lord, matter is a very old matter pending since long. For many decades, the litigation is going on.
29th July. 29th July. Yes.
Serial number 29, there is a letter, Miroz. We are seeking time to file rejoinder.
Letter urgent.
Right.
32 may I 32 item I got pass over. I see my 1 week time to file some document. 32. I see some time to file document. That is very crucial. 32 next week. Next week. Post me. Yes.
May I continue? My lords, I made a small mistake before lunch, my lords. I appear for R4. Dr. Singhi appeared for R3. Mr. Sibal for R2. Mr. Diwan for R1. So I'll say that again, my lords. Mr. Shamdiwan for R1. Mr. Kapil Sibal for R2. Dr. Singhi for R3. I appear for R4. And Mr. Siddharth Luthra will be appearing for R5. I'm so sorry about the mistake, my lords. I apologize for the confusion. We'll, my lords, at the end of the, when your lordship reserves judgment, we'll hand over a list of submissions and compilations per respondent. I'm so sorry about that, my lords. There was just some confusion. I apologize. I'm sorry, Justice Anjari, about that.
Yes.
Yes. Now, my lords, may I just start, my lords, with the little table that I'd handed over on the various types of writs, my lords. And there's a case per the writs. I'll very quickly take your lordships through it. I won't take much time. I promise you, my lords. Your lordships have been very patient, my lords, and I'm deeply grateful. I'm deeply grateful.
Yeah, we have this.
Yes, Didiya. Thank you. My lords, I'm only troubling your lordships with this because I'm just trying to explain that the nature of writs that Article 32 speaks to can exist and are known only in two contexts. One, against a state functionary or the state, my lords. And in the case of quo warranto, my lords, it speaks to the jurisdiction of courts. I will take your lordships. I know your lordships know all this, but I won't take very long on this before I move on, my lords. And I apologize in advance, my lords, for the lengthy nature. But I must confess, my lords, I'm also greedy to argue constitutional law before your lordships. So forgive me there, my lords. Thank you. I'm so grateful. So, my lords, there are these kinds of writs which Dr. Ambedkar, the drafters, discuss in the debates, which I troubled my lords with when I first started. So, my lords, these 5 writs we've prepared this table only for your lordship's convenience, so I won't have to take my lords through multiple layers of submissions. My lords, habeas corpus, my lords, a writ of habeas corpus can only be issued when the detention or confinement of a person is without the authority of law.
We are not concerned with this.
Yes, we're not. Now, mandamus, my lords. Mandamus writ originates from Latin meaning we command. It's a judicial remedy aimed at compelling a public official, corporation, or governmental body to undertake a specific action or perform a duty mandated by law. So this is a governmental body, my lord. This will be a classical Article 12 type body, which is supposed to perform a duty mandated by law. It is only granted, my lords, and this is important, to compel a performance of a public duty. And that's the most important, or enforce private rights when the duties are of a public nature and affect public rights. Now, my lords, certiorari speaks to courts, my lords, courts acting without or in excess of jurisdiction. That's not the case here, my lords. Prohibition is jurisdiction for a grant of a writ of prohibition is primarily supervisory. Where your lordships, my lords, seek to restrain courts or courts that your lordship supervise, which your lordships will often do, my lords. And then quo warranto, my lords, which speaks to the jurisdiction of the High Court to issue a writ of quo warranto. So broadly, my lords, we are of the second type, which is mandamus. And I'm just going to trouble my lords with one case in the nature of mandamus, which speaks to this nature. And then I'll move on from this, my lords. And I'm very cognizant, my lords. I'm taking time, but I'd like to submit with some.
No, you must submit, but
thoughtfulness, my lords, on my part. On my part.
Before we go into sleep mode, you must
No, my lords.
switch on to other.
My lords, my lords, I once saw Mr. Venugopal do this. This was post lunch. The young lawyer had just started at the bar, and this was post lunch, my lords. It was the peak of summer, and my lords, it was a very sleepy courtroom in that time. And I remember he said, "My lords," and thumped the podium. And you know, Mr. Venugopal, my lords, he's otherwise very quiet. He's a real gentleman.
You can also do that.
No, my lords. So I won't need to do this, my lords.
Yes.
My lords, I'll trouble your lordship with only one case, my lords.
Yes.
And that is Vivek Krishna versus Union of India, my lords. My lords can just make a tick of this. We'll submit all of these cases, submissions in a very detailed submission, my lords. This is paragraph 8.
Yes.
Lordship has, my lords. This is 2023 17 SCC, paragraph 8. And paragraph 8, my lords, is internal page 305. The second last page of the judgment. If your lordships will be kind enough to mark para 8, my lords.
Yes.
Given my friends also. May I read, my lords? The writ of mandamus is only granted to compel performance of a public duty or to enforce private rights when duties of a public nature affect public rights or when private rights are breached by or in collusion with public officers. The legal duty that may be enjoined by mandamus can be one imposed by the Constitution, a statute, any law or rules having the force of law which are capable of being judicially enforced. The writ of mandamus is liable to be refused when there is no legal or constitutional obligation of the authority concerned which is capable of being enforced by mandamus. So, my lords, again, it's in its essence, it is the constitutional or legal obligation of an authority. That is when your lordships would otherwise issue a writ of mandamus. This is jurisdiction before. What do you want? My lords, with reference to the other writs, I'll hand over a compilation subsequently when your lordships will allow us to file, my lords. My lords, my friends insist on one other case, my lord. They're very persistent, so I'll read it, my lords. It's called T.C. Basappa versus T. Nagappa. And this speaks to certiorari, but your lordships in that case, 1954, so early days, my lords, just after the adoption of the Constitution. And my lords, in that time, I think in the 50s, late 50s and early 60s, your lordships had a fixed bench. It's a specific bench that heard all constitutional law matters.
Mm-hmm.
My lords, I'll just take you, my lords, to paragraph 5 which starts at page 912. But in the interest of time, I'm only going to read the operative portion. So please go to page 913, my lords. In the middle of the page, your lordships will see an indented portion, which is a quote from Election Commission versus Saka Venkata Rao.
Yes.
Yes, my lords both have this. Justice Anjaria has this. I'm grateful. The makers of the constitution, having decided to provide for certain basic safeguards for the people in the new setup, which they call fundamental rights, evidently thought it necessary to provide also a quick and inexpensive remedy for the enforcement of such rights, and finding that the prerogative writs which the courts in England had developed and used, whenever urgent, necessity demanded immediate and decisive interposition, were peculiarly suited for the purpose, they conferred in the state sphere new and wide powers on the high courts of issuing directions, orders, or writs primarily for the enforcement of fundamental rights. The powers to issue such directions, etc., for any other purpose being also included, with a view apparently to place all the high courts in this country in somewhat the same position as the Court of King's Bench in England. So, well, it's the same point again. I won't belabor it. That it is used to enforce fundamental rights.
Yes.
So, my lords, if this is the case, my lords, that traditionally you will use Part 3 and you will use Article 32 only as a citizen or as an individual against state action, then what remedy does the Union of India, more specifically, which is the more appropriate party, have in this context, my lords? And therein, my lords, I'll take your propositions. I will take your lordships to my next proposition, my lords. My lords have that list of propositions, my lords. So I'll take my lords, to propositions 5 and 6 now. In the nature of what could possibly be the solution here. My lords have this, my lords, Roman 5, Roman 6. I mean, my lords, I'll read them out. If your lordships are not able to find that paper, my lords, I'll read them out.
Yes.
The constitutionally appropriate party.
Yes.
Yes, may I read, my lords? The constitutionally appropriate party here, the Union of India, if in dispute with a state, ought to proceed under Article 131 of the Constitution. Now, I'm going to deal with just these two propositions, my lords, and questions relating to the character of Article 32, writ jurisdiction, union-state dispute, qualify as substantial questions of law, and hence trigger Article 145(3), mandating a reference to a larger constitutional bench. Now, these are the two propositions I'll deal with, my lords. Now, may I first read, my lords, with your permission, Article 131, my lords, of the Constitution. May I read, my lords? 131, Constitution.
Yes.
131, my lords. This is the original jurisdiction of the Supreme Court. May I read, my lords? Subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute. A. Between the Government of India and one or more states, or B. Between the Government of India and any state or states on one side and one or more states on the other, or C. Between two or more states. If and insofar as the dispute involves any question, whether of law or fact, on which the existence or extent of a legal right depends. Provided this is the proviso, my lords, provided that the jurisdiction shall not extend to a dispute arising out of any treaty, agreement, covenant, engagement, sanad, or other such similar instrument, which having been entered into or executed before the commencement of this constitution, continues in operation after such commencement, or which provides that the said jurisdiction shall not extend to such a dispute. The proviso is not triggered, my lords. What is triggered, my lords, respectfully, and what may be an option, is 131C, my lords. B, between the government of India and one or more states, or between the government of India and any state or states on one side, or one or more states on the other. This is what the Constitution envisages, my lords, in terms of a dispute such as this. Now, why do I say this, my lords? May I just amplify the argument that I'm trying to develop? May I just take you to the case, my lords, which is State of Karnataka versus Union of India. So your lordships will see, my lords, clause A of 131 deals with disputes involving the government on one side and one or more states on the other. B deals with disputes involving the government and or a state on one side and one or more states on the other. And clause C deals with disputes involving any question of legal rights and to what extent or existence such legal right depends. So this is, my lords, the nature of this. I'll just take your lordships to a case to handle the petition. So, my lords, that if and insofar as the dispute involves any question, whether of law or fact, on which the existence or extent of a legal right depends. That is the nature of what 131 is supposed to be. And this is what your lordships have said as to what this means, my lords. My lords have this case, my lords. It's State of Karnataka versus Union of India and another, 1977, 4 SCC 608. May I read, my lords? So your lordships will see, my lords, and the facts, this was the central government had appointed a commission of inquiry there against the Chief Minister of Karnataka. Now, may I take you straight away, my lords?
Now, what right of the state is involved in this?
No, my lords, it is that if there is a dispute, that's why I'll just read.
No, what is the dispute in this case between the state and the union?
No, my lords, if there is a dispute, and here the dispute may well be, this is the extent of...
No, we are sorry.
Yes.
This is not a dispute between the state and the central.
My lords, here the union...
You cannot, you cannot walk in.
Yes.
Any chief minister of any state,
yes,
just walk in the midst of an inquiry or investigation and make the democracy in peril and then argue that it's a dispute essentially between the state and these are individuals.
My lords, when
Incriminating evidence is taken away.
Yes.
Incriminating evidence is taken away.
What is this kind of, don't convert into a dispute between the state and the union. This is not per se. This is per se an act committed by an individual who happens to be the chief minister, keeping the whole system and whole democracy in jeopardy.
My lords, respectfully, I'll disagree with that. And I'll show you why. Please allow me to just develop my argument and I'll show you why.
Yes.
Yeah, please allow me that, my lords. I'll just develop the argument. I'll also place for the possible question and dispute under 131. So I will start, my lords, by just reading what does 131 speak to. Your lordships has this, my lords, paragraph 146.
Which central government or ED officer can see an inquiry by CBI in a suit under 131? Tell us.
My lords,
whether that relief can be granted.
My lords, we are not
by the Supreme Court.
No.
Directing a CBI inquiry in 131 suit.
No, my lords, but here they are not asking. They are saying that their officers' fundamental rights are being violated. That is their case.
No, that is their case.
That
but
is their case.
Harpreet
They have come
Kaur,
to you on this.
You are saying that if at all this can be maintainable,
Yes.
this cannot be maintainable under 32, but it can only be under 131.
No, my lords, I'm not
That is
saying
what your
it can
argument.
only be. That we have a legal question, perhaps, that has not been countenanced before, that has not been formulated before, that there may be a legal issue between what should be the union, not the enforcement directorate, not two individuals who are officers of the enforcement directorate under 32. That is my only point. That is my only point. They have not come under 131. They have not even come as the Union of India.
No, but it's your suggestion.
No, I am saying if your lordships were looking for a plausible way, then that plausible way would certainly not be a writ petition, a 32 petition. There may be a dispute between the union when the necessary party and the proper party would be the Union of India and the proper party would be the state. That's all I'm saying. That's all I'm saying, my lords.
Therefore, we are asking
Yes.
whether in 131 suit, a relief of this nature, seeking direction for a CBI inquiry, can be sought in 131 suit.
My lords, but they are not seeking that.
They are seeking.
They are seeking the fundamental rights of the officer being violated. They are saying the fundamental right of the officer is being violated, and therefore they want a CBI. There's a difference there, my lords. They are not coming as a suit. They are not coming as a suit. They are saying this is a fundamental right violation of these officers who are officers of the Enforcement Directorate, which is a department of the state of the Union of India. You can trace it from the Ministry of Home upwards. That is all I'm saying. And to that extent, we're just saying, my lords, I'll just take you to para 146. Now, this is their framing, my lords.
146, sir?
Yes, of this case.
Judgment.
Yes.
Yes. You see, you have taken us through Sirvai, to Ambedkar,
Yes,
to Keswanand Bharti,
numerous other cases also.
but none of them
Yes.
would have ever conceived of this situation that in this country a day will come when a sitting chief minister will walk in to the office of some other investigating agency.
Yes, when we come to facts, we will assure and we will convince. I am still on my legs, if I may please finish. I am still on my legs. My lords, this is only Mr. Mehta grandstanding for whoever he thinks is not in.
You see,
This.
we are saying that it is proved as of now. But
Yes.
the facts
And we
on
come
which
to the
the-
facts, my lords. I am
on which both the
I'm on
petitions are
maintainability, my lords. With respect, I'm on maintainability, my lords. When and if and when we come to the facts, then certainly we will convince your lordships. We will do our best to convince your lordships. And as for grandstanding, my lords, it has no place in a courtroom. There's no place in a courtroom. Now, my lords, may I just read para 146?
Sometimes even responding is degrading your own dignity. So, respectful silence is my response.
My lords, I don't know what these similes and homilies the SG speaks in, my lords, but I'm sure he's convinced himself. It has to be remembered that Article 131 is traceable to Section 204 of the Government of India Act. The jurisdiction conferred on it thus originated, my lords, page over, your lordships has that.
Yes.
Thus originated in what was part of the federal structure set up by the Government of India Act 1935. It is a remnant of federalism found in the Act. It should therefore be widely and generously interpreted for that reason too, so as to advance the intended remedy. It can be invoked, in my opinion, whenever a state or other states or the union differ on a question of interpretation of the Constitution, so that a decision of it will affect the scope or exercise of governmental powers which are attributes of a state. It makes no difference to the maintainability of the action if the powers of the state, which are executive, legislative, and judicial, are exercised through particular individuals as they necessarily must be. It is true that a criminal act committed by a minister is not part of his official duty. But if any of the organs of the state claim exclusive power to take cognizance of it, the state as such becomes interested in the dispute about the legal competence or the extent of powers. So, my lords, this pertained to a commission of inquiry. And this was framed then as a dispute between the union and that state. Therefore, I'm citing this, and I will come back to this. Now, if your lordship is then considering possibilities where there is a legal dispute, a bona fide legal dispute, then all I am suggesting is the Constitution provides pathways. The Constitution certainly doesn't intend for official functionaries of a state agency, which is fairly powerful, to come to your lordship's court and say, my fundamental rights are violated. Finally, my lords, if there is, I'll very briefly touch upon the last proposition in that list, my lords.
145.3 about.
Yes, my lords. My lords, I'll just read the proposition and then I'll take you to Article 145. Questions relating to the character of Article... I'm sorry, my lords. So the last proposition, my lords, is questions relating to the character of Article 32 writ jurisdiction, union, state dispute, etc., qualify as substantial questions of law, if any. The union could have done this maybe somewhat more appropriately, my lords, or more legally tenable. But they've chosen the most legally untenable way to advance whatever alleged grievance they have, and we are not here on facts. We are only here on maintainability. We are only here on that. When we come to the facts, your lordship will see there is no situation as described by my friends on the other side. And I'm very cognizant as an officer of the court when I say that. There was no criminal conduct, there was no intimidation, there was no infraction of any official. Questions relating to the character of Article 32 writ jurisdiction, union, state dispute, etc., qualify as substantial questions of law and hence trigger Article 145(3), mandating a reference to a larger constitutional bench. Now, may I just read, my lords, Article 145. My lords, rules of the court, etc. 145(3). My lords have that. My lords, may I read, my lords?
Yes.
Yes. 145(3), 145 being rules of the court, etc. 145(3). The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution or for the purpose of hearing any reference under 143 shall be 5. So if there is a constitutional case, my lords, a question as to whether this dispute interstate between a state and the union, which apparently is not even here, then your lordships may consider that in the context of Article 145(3). Now, may I just take you, my lords, to what is the nature of the 145(3) jurisdiction? And what, if any, pertains to the interpretation of Article 32. That is why, my lords, in the first part of my arguments, I spent so much time developing what is 32 intended for. Now, I'll just start, I'll trouble my lords with one case. My lords, this is Srimant Balasat Patil versus Karnataka Legislative Assembly. What is this? Sorry, ma'am. Please hand it. There are 20 bills. No?
No, this is M. Siddiqui.
Yes, ma'am. M. Siddiq through legal representatives versus Mahant, Suresh Das and others.
You said some bollocks.
Yeah, I'm sorry, my lords. I misspoke on that. We'll just go with this, my lords. I don't want to trouble my lords with too many cases. I'll trouble my lords with this case. M. Siddiq through legal representatives versus Mahant Suresh Das. And I'm only using it 2019-18 SCC 631. I'm only using it to show your lordships paras 101, 102 and 150. I'm just going to use it to show your lordships the nature of what is considered to be a 145.3 question. And then I'll suggest some possible framings for a 145.3 question.
Yes.
Yes. Now, may I take my lords to paragraph 101? This would be, my lords, page 689.
Yeah.
My lords, as per your lordships have it, may I read, my lords? As
Yes.
per the proviso, the reference to a bench of 5 judges can be made by judges sitting in lesser strength than 5 judges while hearing an appeal on the fulfillment of the following 2 conditions. The court is satisfied that the appeal, these are the 2 conditions, my lord. 1. The court is satisfied that the appeal involves a substantial question of law as to the interpretation of this constitution. 2. The determination of which is necessary for the disposal of the appeal. Now, please see, my lords. So, 1, it involves a substantial question of law. Law pertaining to what, my lords? As to the interpretation of this constitution. And then I'll suggest some possible questions, my lords. And 2, the
But before that,
Yes, my lords.
in an appeal,
Yes, my lords.
this is not an appeal.
My lords, but this
We
is
are dealing with both the petitions under 32.
Yes, but my lords, then therefore I'll be framing the question with regard to
No. For in every question there will be some question of law.
No, my
That
lords.
doesn't mean
My
that
lords,
every 32 petitions should be
this
sent
is
5 judges.
this is a unique proposition which they are advanced, unknown to Indian constitutional law, my lords.
We do not
Unique.
know who has
Unique proposition.
who has mooted their
My
proposition.
lords, in 75 years, we have never seen a proposition such as this. Never seen a proposition such as
What
this.
proposition?
The proposition that the enforcement directorate's employees
No, these propositions
have
are
Article 32 right.
now they keep on coming.
No, my lords,
Every state is filing 32.
And when your
every other.
lordships are confronted by the enforcement directorate's conduct, your lordships in contemporary times have only reined in the enforcement directorate in the context of privacy, in the context of search and seizure, and in the context of overreach. That is what your lordships have done in the last 2 years. And when we come to the facts, my lords, if we do that, we will take your lordships to those cases.
We will decide whether 32 is maintainable or not.
Yes, my lords, and that is what we are arguing about.
What is that substantial question of law which requires to be heard by 5 judges bench?
No, my lords, whether
And that
in fact,
in a 32 petition itself.
my lords,
Read 101 again.
Yes, my lords. Where the court is satisfied that the appeal involves a substantial...
Appeal involved.
The appeal.
We are not dealing with appeal.
Yes.
We
So, my
are
lords,
dealing
what
with 2 writ petitions.
Yes, what I'm
So
suggesting...
first prerequisite is not satisfied.
Yes, but what is satisfied is that there is a substantial question of
No,
law.
but that should be
which
in an
pertains-
appeal. That should
which
be in an appeal.
pertains A substantial question of law.
We are
which
not hearing an
pertains to an interpretation of the Constitution. Because a petition like this has never been advanced before, it poses a substantial question of law, which your lordships.
Sorry,
have
we
to
are not
consider.
hearing an appeal. We are not hearing an appeal.
But my lords, have your lordships ever considered a question?
Otherwise,
as to whether-
in every petition, there will be some question of law which you will say needs to be referred to larger bench.
My lords, the Sabrimala review which your lordships are now hearing, is the review going to a larger bench?
Yes, it can.
The review is going to a larger bench because your lordships felt convinced that there is something in the review which poses a large-scale constitutional dilemma.
When either of you come in review before us, we will decide that.
No, but my lords, the point is that when there is a substantial question which involves interpretation of the Constitution, then if your lordships feel it arrives at that height,
Mr. Sibal has joined.
that your lordships must refer it to a larger bench.
His arguments are over, his submissions are over, he must have joined.
Yes, yes.
Just to be enlightened.
Yes, yes.
My lord, so that is the point, that when your lordships are satisfied, just like in Sabrimala, your lordships felt there was a constitutional dilemma that was posed, which the review presented. And then my lords created and put together a 9-judge bench. Similarly, here I am saying, my lords, whether the Enforcement Directorate can prefer a writ under 32 poses a constitutional dilemma for this court, where for the last 75 years, we've only understood Article 32 to be in the nature of enforcement of fundamental rights questions. That is the question that my friends are posing. And that, in my respectful submission, warrants then that to be referred to a larger bench if my lords feel that there is something meritorious in their submissions. That's the only point, my lords. Now, my lords, this is what is pending before the High Court, my lords, of Calcutta. May I just hand that over, my lords?
Yes.
Let's see. What is that? What is the same? 609. This is the petition, my lords. So it is misspelled, my lords, the cause striking, but it is this. My friends, the Directorate of Enforcement, in the cause title, my lords, will see it's Directorate of Enforcement versus the State of West Bengal. Now, this petition, my lords, is pending before the High Court. And this is a live petition pending before the High Court, where my friends are there argued that the petition is pending before you. Now, I'm saying, my lords, that this is just my friends exercising forum shopping rights, my lords. And your lordships will see, my lords, that this is exactly the same petition. For the petitioner, the CBI is also there, my lords. The state is there, and respondents 1, 3, and 5, my lords. May I just read this quickly, my lords? Learned Counsel for the petitioner seeks adjournment on the ground that the Enforcement Directorate, and the petitioner here is the Enforcement Directorate, has filed a special leave petition before the Honorable Supreme Court with prayers which are almost identical to the present application. The Honorable Supreme Court is seized of the matter. The respondents are ready and willing to proceed with the matter before this court. In view of the fact that the Honorable Supreme Court is seized of the issue pending before this court, judicial decorum demands that this matter be adjourned till the SLP is disposed of.
Yes.
They were arguing this in the High Court, and now they are arguing this before your lordships. And can you have two virtually identical petitions, my lords, pending before two constitutional courts, my lords? You are two layers of constitutional courts, but both of you are constitutional courts, and that's the larger question that remains. Now, my lords, the one submission that I will respectfully press is this, that today the question before your lordships is a very substantial question. It speaks to maintainability, it speaks to interpretation of the Constitution, and it is a substantial question that speaks to interpretation of the Constitution. And that question is simply this, that whether the Enforcement Directorate can prefer a writ petition under Article 32 of the Constitution. Respectfully, they cannot, my lords, because Part 3 rights are not available to them. They are not an individual or a citizen. 2, my lords, First one, Mr. Diwan argued about the meaning of juristic person, which in fact, my lords, whether they do or they do not, but be that as it be, the reason why I took my lords to Article 131 and 145 is these are substantial questions of law, which demand and mandates a constitutional resolution. Because such a question has not been entertained by the courts before, because such a petition has never been entertained by the courts before. And if your lordships find this petition to be maintainable, then it infracts upon an understanding of basic structure, which Keshavanand deals with. It infracts on an understanding of what are Part 3 rights, which the framers of the Constitution had in mind. And it infracts on jurisprudence from 1950 onwards on who and what can bring an Article 32 question before your lordships. So therefore, respectfully, my lords, this nature of question must necessarily then go to a larger bench, my lords. And hence, my lords, I'm saying 145. Yes. And my lords, may I just read the first part, my lords? Yes. May I just read 145.3 here, my lords? The Constitution. May I just take your lordships to it, please?
You have read it.
My lords, may I just read the provision now? The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this Constitution, or for the purpose of hearing any reference under Article 143 shall be 5. So the text of the Constitution, my lords, the minimum number of judges who are to sit for the purpose of deciding any case. So, my lords, is not just an appeal, it's any case. So, my lords may just mark that out. It's any case involving a substantial question of law as to the interpretation of this Constitution, or for the purpose of hearing any reference under Article 143 shall be 5. So it's any case, my lords. It's much larger than an appeal. Now, please see the proviso. Provided that where the court hearing an appeal under any of the provisions of this chapter other than 132 consists of less than 5 judges, and in the course of the hearing of the appeal, the court is satisfied that the appeal involves a substantial question of law as to the interpretation of this Constitution, the determination of which is necessary for the disposal of the appeal, such question shall refer such court shall refer the question for opinion to a court constituted as required by this clause for the purpose of deciding any case involving such a question, and shall, on receipt of the opinion, dispose of the appeal in conformity with such appeal. So the first part of 145.3, my lords, Article 145.3 is any case. The second component of it is substantial question of law as to interpretation of this Constitution, which in this case is, can the Enforcement Directorate bring an Article 32 question? And the second part, the proviso, the court is satisfied that the appeal, the proviso provides for this, involves a substantial question of law as to interpretation of the Constitution. And the proviso can't control the main provision. The main provision is clear that it is any case, and this would qualify as any such case. I'm grateful.
Yes, Mr.
Yes, sir.
Yeah, absolutely.
Yeah.
So what I've done is I appear for respondent number 5, the GCP. I made a note, and since some of this work has already been done, I would not repeat the arguments that are already made. And for another note, please. Yes, sir.
My lords, before Mr. Luthra commences, we'd also file written submissions, my lords.
Yes.
Trouble your lordship with
Yes.
that. And a compilation also.
Yes, please.
I'm grateful. Yeah.
Just read this. It is precedent. Just to, my lord may just see the note for a moment, and I'll just summarize it now, because some of the judgments have been covered. The first point, Lord, in the first head point, my Lord, just has the note Roman 1, Lord, is that ED cannot file a writ petition under 32, not a person, not have fundamental rights to invoke 32. I put it in the bold and top. And I mentioned that this dispute is ongoing, being heard in other matters. So far as ED is concerned, my point is it is an agency of the union, no separate identity, power circumscribed, it's in my first point in the note only, circumscribed by the PMLA and the FEMA, and even section 36 note, which I have reproduced below at the bottom of my note, says ED is an internal department of the Ministry of Finance. Just read this with me, 36, which is quoted at the bottom of my note. The central government shall establish a directorate with a director and such other officers or class of officers as it thinks fit, who shall be called officers of enforcement for the purpose of this act. And then it talks about how it may, what is the hierarchy. And 3 says, subject to conditions and limitations as the central government may impose, an officer of enforcement may exercise the powers and discharge the duties conferred or imposed on him by under this act. So it is really a department of the government. ED, with respect, not and STC has been quoted, Telco has been quoted, is not a natural citizen. And I would respectfully submit that only natural citizens can invoke or maintain Article 32. And even in Vijay Madanlal, this position has been made to be unacceptable. An argument was made under Article 131 suits. My learned colleague before me mentioned that. I must tell your lordship, there is a 31 article section, Article 131 suit which is pending. And what is interesting, of course, about the CBI is not, there is, as your lordship knows, the CBI's very existence is under challenge and it is operating in terms of the stay order granted graciously by your lordships about more than a decade ago, more than 12, 13 years ago. That time I was on that side, of course. I'm not, in this suit, there are very interesting pleadings, and I want your lordship to see that. So the suit, original suit, sir. Suit number 4 of 2021, sir. No, what is the written statement? Just the written statement, sir. Just the written statement.
Some other proceedings can't be just placed before the court. There are no averments in the affidavit. He has not even filed an affidavit.
I have filed it. I filed it.
But there's nothing. I didn't find anything of this. This is not the way.
I'll show it.
We are still, I have yet to open.
5 minutes, 5 minutes.
I have yet to open. My learned friends are only opposing why you should not, lordship should not hear.
I'm only pointing out in para 10 what is the stand taken regarding not only the.
You tell us.
No, I'll tell you.
Yes, you tell us what.
But the point is this.
This CBI, he has nothing to do with this.
Sir, actually, page 9 of that, the written statement
will take.
Sir, page 9, I may just point out, and I'll read what is said, not
as this is the culture of this court. You can refer, you can place before the court any document, whether it is part of the record, not part of the record. And in the ends of justice, everything is permissible in this court.
But that is true.
And since everything is happening for the ends of justice or injustice. Yes, please.
From justices, only justice can fall. Injustice cannot fall.
No, injustice can only come from that side.
Lord, I'm not disagreeing with your lordship on that. I think not on a lighter note, not we are all in the cause of justice. Eventually, your lordships are the arbiters. One way or the other, one side is going to go away not so happy, one side is going to go away happy. That's the only difference. But eventually, what is going to fall is going to be the law of the land. Please come to page 9 of this. Please come to page 9 of that brief statement.
Yes, you tell us.
There's your lordship. But I will tell you, but if your lordship is not inclined to read it, then with me it becomes a handicap. But anyway.
No, since it is not part of the record, we are hearing you only.
Oh, I'm so grateful. Please come to para 23, Lord, at page 8 bottom.
Since you are insisting,
I'm pleading. I'm not
that you may not feel that you were not heard properly.
Lord, I never.
We'll go through it. We'll go through it.
I never have the grievance that I'm not heard properly. I know your lordship is too particular.
In a case of this nature, anybody can have any grievance anytime.
Well, others might. I think your lordship knows me well enough from a long time that I'm not one of those people to have such grievances.
Because this is a constitutional issue, anybody can think anytime. Yes, next.
Page 9, Lord.
Page 9 or para 9?
Page not it's para 23, but at page 9, my lord, of the written, not the suit, Lord, written statement, just the written statement. It's time, Lord.
Which page it starts?
Lord, I'm sorry, my learned friend would have put a flag.
There's no flag in
Not there differently tagged. The written statement would be at the. Why didn't we give it separately as a statement? I'm extremely sorry, Lord. I'm similar, I'll just separate it. I'm sorry. There's a lapse in our end.
No, there is. It's paginated. You refer to the page.
My lord,
You are referring what?
Lord, I was referring to page, Lord, para 23 of the written statement. Lord, there seems to be, what I have is somewhat different than your lordship. Lord, may I just separate and give it to your lordship from there? I'm sorry for this.
Your pages are topsy-turvy.
I know that, your lordship. Your lordship is right. It's not fair to your lordship. DGA. You have to flag them for the bench, ma'am. You have to flag them for the bench.
Tell her to flag it, and in the meanwhile, you tell us.
It's already tagged, Lord. I just tell you, Lord, it's already tagged. What happened was both of them should not have been clipped together. It's an unnecessary inconvenience for your lordship. I'll just pass it on. Lord, this is it. This, Lord, page number, it became into 8. Page 9, Lord, writes, para 23, Lord, and page 9 on the top. As a result, this is the stand taken by the union, Lord, in pleadings. As a result, the Delhi Special Police establishment of the CBI would now be a central police force and not a police force of the state. The CBI would thereafter stand on the same footing as a police force of the union or as a central investigating agency similar to the National Investigating Agency, the Income Tax Department, the ED, the Department of Central Excise, the Narcotics Control Bureau, though under the superintendence of the Central Vigilance Commission by reason of so-and-so as it relates to investigation. If this be so, no question of consent of states to enable. Not the point that they were making was, you can't maintain a suit when the party is the ED because the ED is just a functionality or a department of the union, the CBI, and the principle that the point that was made was CBI is akin to other departments. That's all I wanted to place before your lordship. And this is the stand which led to the judgment which my learned friend had placed before your lordships. Now, Lord, the point that I seek to make is, there the union had claimed that the suit will not lie, and the point similarly here is that ED cannot claim an independent identity of the union before this court as well, although it may, for the sake of not form, be marked as a department of the union, but it has no independent identity. Now, Lord, please come to point number K, where I've quoted the para. My learned friend had read Motilal. Motilal, Lord, is followed in Shiv Prasad, and Shiv Prasad's para is quoted. Para came. The issue of whether the government can be deemed to be a person within the meaning of the expression as used in Article 14 of the Constitution was first raised in Motilal, 1951, Allahabad, and then finally in Shiv Prasad, wherein the court observed The natural and obvious meaning of the expression person is a living human being, a man, woman, or child, an individual of the human race. As used in law, the word includes natural persons and artificial persons like corporations and joint stock companies, but it does not include a state government or the state of government. For those states in the language of battle, a moral person having an understanding and a will capable of possessing and acquiring rights and of directing and fulfilling obligations. The state in its political organization is entirely different and distinct from the inhabitants who may happen to reside there. Similarly, a government cannot fall within the ambit of the expression person. Thus, neither a state nor a government can fall within the ambit of the expression person appearing in Article 14. Now, thereafter, I also referred in para L on the next page to a German case. Now, the German case have you got the confirmation is quoted here, but I'm only citing 3 or 4 judgments, but unfortunately they're compiled together. Kindly just see that. In the German case, cited in D.D. Basu's commentary lot, 9th edition, volume 4, page 954. May I request your lordship not the original text of D.D. Basu is reproduced as serial number 22 lot at page 392 of that compilation. And please come to 396.
Yes.
Please come to 396 plot. The third para, second para. But the enforcement of fundamental rights would not be covered by any of these exceptions to Article 131. Hence, the union or state cannot sue such each other for violation of their supposed rights. The status of government corporation or corporations exercising public functions requires separate treatment. It may be stated at once that if allowed to claim that these may be regarded as agents of the state, they cannot be allowed to claim fundamental rights by analogy. This is made clear by a decision of the West German Constitutional Court. Article 19.3 of the West German Constitution expressly confers basic rights upon corporations to the extent that the nature of such rights permits. But the Constitutional Court has held that this provision would not extend to corporations which perform public functions and exercise state powers. The reason given is illuminating. Quote, the basic rights according to their nature was intended to protect the sphere of freedom of the individuals against encroachments by state authority. Consequently, the state could not be at one and the same time the party against which the basic rights were invoked and the party entitled to exercise them. The reason aforesaid is unquestionable, and there is no reason why it should not be applicable in India. This is the view brought by one of our well-known authors on law, Mr. D.D. Basu. I would also draw your lordship's attention to a US, this is a Court of Appeals judgment at page 378 of that compilation, Lord Oni versus Oklahoma City. Oni will be 378. And just one sentence here. If your lordship is kind enough, come to 382, not just the one sentence. It's a third para on that page, not 382. Yes, the US Court of Appeals. US Court of Appeals. US Court of Appeals. No, I said Court of Appeals. I said US Court of Appeals.
Mr. Luthra has been assigned the task of referring to all foreign judgments, Germany, US. 382, yes.
Well, not one tries to say something others have not said.
Yes,
otherwise I would be repeating myself.
That is exactly what I'm trying to convey.
I'm grateful, Lord. No, your lordship is very kind. But my learned friend, of course, said that it's a district court. He forgets that I'm a trial.
He will never be.
Else will I cite?
He will never be kind to you.
No, you are not a trial court.
I am a trial court.
That's why you are not.
I'll never be kind to him. Always not. He and I I must tell your lordship, we have an old and very good personal relationship, and there has never been a gap for more than 20 years.
Yes.
And whatever our jibes at each other in court, outside things are
something totally different.
That happens.
When your lordship was
Inside court and outside court, they are totally different.
as it ought to be.
Atmosphere is totally different.
And even in court, not we must, in all fairness, we must always be gracious to each other because after all, we are learned friends. I'm not 382.
And when you fight also, you fight it graciously.
It has to be. It has to be. That's what we learned from our seniors.
Yes.
382 law. Third part. The liberty guaranteed by the due process clause is the liberty of natural, not artificial persons. That's the one sentence I wanted to place for. This was the case for, of course, in relation to a dispute in relation to the Jehovah's Witnesses, but that's the point I wanted to make. And it's quoted also with approval in D.D. Basu, but I won't read that again. Now, my submission to your lordship is this, therefore, that 32 is not a right available to the ED, not a person, not a citizen, not a citizen. Now, Lord, please come to section 2 of my submissions for a moment. The incident is of 8 January 2026. They first go to the High Court on 9 January. They prefer a writ petition. Matters adjourned on 14 Lord. Meanwhile, they prefer it. The question really is, can they maintain 2 petitions at the same time? My Lord, I'm not going to repeat judgments by citing them. Pratibha Ramesh Patil, I have not, just give me another copy. That's a loose copy, Lord. I've already quoted text.
It is here, page 4. Page 4, clause C. In your note,
Lord,
Pratibha Ramesh Patil, 2015-12 SSC.
Yes, Lord, it is there, but the copy I'm handing over because I'm not. My Lord, may just note paras 8 to 10.
Yes.
Because D will say the same thing, my Lord. And I'll just read this and
Para 8 to 10.
Lord, in fact, para 8 and 9 is good enough, Lord. Virtually, the writ petition filed before this court is a true copy of the writ petition filed by the petitioner under Article 226 of the Constitution before the High Court, except for disclosure of the pendency of the writ petition and some other minor changes. What is revealed from what we narrated above is certainly shocking. The petitioner having filed a writ petition before the High Court under 226, writ petition having been admitted by the High Court having granted an order which will work itself out, petition is still pending. Filing a petition under 32 before this court is nothing but an abuse of the process, if not misuse. Having invoked a constitutional remedy before the High Court under 226, petitioner cannot under law file another petition under 32 seeking an identical set of relief words. And in this regard, Lord, P.N. Kumar gives us some illustration, Lord. P.N. Kumar, Lord, in para 2, I won't read. P.N. Kumar, Lord, para 2 is very, very educated.
P.N. Kumar.
Para 2, sir, para 2. P.N. Kumar, come, Lord, please see. Para 2. Here, and I'm going to only read select paras, Lord. We are of the view that this petition should be disposed of without expressing any opinion on the merits of the case reserving liberty, if so advised, be accordingly disposed of for the following reasons. 2. The relief prayed for in the petition is one which may be granted by the High Court, and any of the parties who is dissatisfied can approach this court by way of an appeal. Fact that some case involving the very same point is pending in this court is no ground to entertain the petition directly bypassing the High Court. 5. Our High Courts are High Courts. Each High Court has its own traditions. They have judges of eminence who have initiated necessary skills and enthusiasm. Their capacity should be harnessed to deal with every type of case arising from their respective areas which they are competent to dispose of. Then 6 talks about eminent counsel, Lord. 7. This court has no time today even to dispose of cases which have to be decided by it alone and by no other authority. Large number of cases are pending from 10 to 15 years. Even if no new case is filed, with the present strength, it may take more than 15 years to dispose of all the pending cases. If the cases which can be filed in High Courts are filed in the High Court and not this court's task for acting as an original court, which is a time-consuming process, can be avoided. And the court will also have the benefit of the decision of the High Court where it deals with an appeal. And then, Lord, it talks about the dignity and majesty of the High Courts and the efficiency, and time would be saved in 9 and 10.
So the point is not, having filed in the High Court, whether they should have come here at all. My respectful submission is not, you can't have two shots at the same apple. Now, Lord, Roman 3. My Lord put a question to earlier counsel also, that it's an unprecedented matter, unprecedented circumstances. A public servant of the rank of Chief Minister has gone and allegedly raised a ruckus, and therefore this kind of circumstances never happened before. I think not two things which we must keep in mind. Firstly, not, please come to point Roman 3.c lot. We have remedies within the law. Sakiri Vasu provides for this. Babu Venkatesh lot provides for this. I have the loose copy, just pass it over. Priyanka Srivastava provides for this. Tunga Nima Lepcha has been read, so I won't repeat that. But let us see not Sakiri Vasu's case for a moment, which is serial number 9 in the compilation. I know your lordship has read it on many occasions, but let's have a glance at one or two paras at page number 182. With the other judgments, ma'am. Priyanka de dijiye. But Sakiri Vasu at page 183. Para number 9. The petitioner prayed in the writ petition that the matter be ordered to be investigated by the CBI, since his prayer was rejected by the High Court, hence his appeal by way of special leave. It has been held by this court in CBI versus Rajesh Gandhi that no one can insist that an offence be investigated by a particular agency. We fully agree with the view in the aforesaid decision. An aggrieved person can only claim that the offence he alleges be investigated properly, but he has no right to claim that it be investigated by any particular agency of his choice. In this connection, we would like to state that if a person has a grievance at the police station is not registering his FIR under 154, then he can approach the Superintendent of Police under 154.3 by an application in writing, even if that does not yield any satisfactory result, in the sense that either the FIR is still not registered, or that even after registering it, no proper investigation is held. It is open to the aggrieved person to file an application under 156.3 before the learned magistrate. If such an application under 156.3 is filed, magistrate can direct the FIR to the district, also director to the aggrieved investigation to be made in a case where, according to the person, no proper investigation is made. So, not this position of law is unacceptable. And my lord, we just make a note of para 17 and 26.
According to Sakri Vasu, they should have approved the.
But if they have a grievance, and I'll tell your lordship why. I'll tell your lordship why not. This issue was dealt with also in Priyanka Srivastava, not which is here, not it's serial number 15.
See, I have been repeatedly commenting. If I make an observation again, you will retaliate definitely. You means all of you,
not me.
As a council, not
yes,
Mr.
your lordship puts a query, not we have to.
This is an extraordinary situation. Before the other bench, where the FIR is under debate or under question, whatever. Yes, we have seen the situation that several judicial officers have been kept hostage, and now you want that the petitioner's hearing should go to a magistrate by lodging a complaint under section 200. Think of this. You see, we cannot shut our eyes from the realities of what is happening. You may argue as a council, you may argue abstract legal principles before us, but we cannot lose sight of the practical situation which is occurring and which is present on the spot in the state.
Not in fact.
But don't compel us to make observations. Tomorrow it will be reported, and then you will say court has made observations and it is reported in the midst of elections.
I must tell you.
But what can we do?
I must tell you, lordship, I maintain a rule. Cases I do, I don't look at the media or talk to the media. There's no point. But I must answer this. Your lordship put a very important query to me and say, coincidentally, I must tell your lordship, I did not appear for the state there, but I was asked to appear for the chief secretary, the DGP, and the home secretary because they specifically engaged me in that matter.
I am repeatedly saying,
and I'll tell your lordship,
this is not a litigation between Ram versus Syam. or Sukhru versus Samaru, we call it Chhattisgarh.
Yes. Yes, sir.
This is an extraordinary litigation where the contours are totally different, and we always say we are in, like Constitution is an organic document. Every new situation will throw and pose new questions to the court, and the court has to answer those questions, keeping in view the present socio-political realities. The interpretation of Constitution and other provisions keep on changing. There are decadal changes in interpretation. Otherwise, why should we overrule our earlier decisions? Why should after 5-9 hour sitting? It is ever evolving process.
Lord, I must say this: what is fallen from your lordship on the evolving process unacceptable, and I could be
And the evolving process in the evolving situation, you are the creator of that situation and that process and that question or the whole litigation.
Lord,
Some situation will always be created. Tomorrow there will be some other situation, and we will again be required to deliberate upon all these questions again. Some other question, some other officer will do. It is not that everything is decided in this court. Courts are meant for deciding new questions which arise in every new situation.
My Lord, if I may say so, and I bow before your lordship's point of view, but I must also, Lord, tell your lordship in all fairness, Lord, let's break it down to brass tacks. What is it? What is the worst? What is the worst that is an allegation? An offense under 186 is an offense of interfering with a public servant. I'm looking at it, Lord. Let's look at purely in the offense perspective. If that be the case, my Lord, and I must point out, and I'm grateful your lordship said that, Lord, please come to not Roman 4, but come to G on the next page. G. In G, Lord, I have quoted for your lordship's convenience
Roman 4G.
Roman 4G.
The present case is not the first of its kind.
Yes, Lord.
Page 7.
Similar cases have arisen. Yes, Lord. I'm grateful in the past and have been dealt with in accordance with provisions of IPC and the CRPC. For instance, Naib Tahsildar of income tax, one superintendent was beaten, 3 warrant of attachment, district magistrate, members of a trap team. My Lord, eventually, what are we saying? Irrespective of the offender or the alleged offender, the allegation is that an officer says, I was obstructed. Whether that offense has or not taken place, I'm not delving into that issue. But the moment the officer says that I was obstructed, there is an offense which is under the IPC. And for that, there is a mechanism in law. That mechanism is tried and tested since 1860, not because 1860, as your lordship knows, we have the penal code. 1868, we got the first criminal procedure code, then 1872, and then 1898, and now, of course, we have the BNSS. So the point that I seek to make is there will be mechanisms not under the law regarding prosecution. There are mechanisms, of course, regarding sanction, if necessary, if required not. And those mechanisms exist in the law. It cannot be that show me the individual and I will show you the law. That cannot be the situation, as your lordship repeatedly reminds us. The law has to be consistent and has to be acquired, and that's what your lordship does day in, day out. As I said, Lord, some of us will walk away happily, some of us will walk away less happily, but we all walk away that the law has been acquired. The axe falls straight, neither left nor right, but it falls exactly at a straight degree. So therefore, Lord, my respectful submission is, and I leave it to your lordship with that thought, Lord, I put those illustrations, I put those judgments. It is also a case where, if I may just point out, Lord, and above G, Lord, I've also quoted the provisions which would, if at all, apply. 186, 353, 221, 132. These are the only provisions of the provision that will be applicable. And if that is the case, is it a case for 32? Lord, lastly, since your lordship put to me, Lord, there's one interesting, and I put the judgments on the notes now. I don't want to take more time from the lordships, but there's the Constitution Bench judgment, which your lordship has seen many times over. I'm sure it has been quoted here as well. Para 68 is quoted, but para 70 tells us the contours, Lord. I'm just handing it over. On transfer to CBI. Please just come to para 71. That's the test that is to be applied. 70, 70 last one.
Para
70 mark. The Constitution bench block. Last page, or just the last.
yes.
Before parting with the case, we deem it necessary to emphasize that despite wide powers conferred by Article 32 and 326 of the Constitution, while passing any order, the courts must bear in mind certain self-imposed limitations on the exercise of these constitutional powers. The very plenitude of the power under the said articles requires great caution in its exercise, insofar as the question of issuing a direction to CBI to conduct investigation in a case is concerned, although no inflexible guidelines can be laid down to decide whether or not such power should be exercised, but time and again it has been reiterated that such an order is not to be passed as a matter of routine or merely because the party has leveled some allegations against the local police. This extraordinary power must be exercised sparingly, cautiously, and in exceptional situations where it becomes necessary to provide credibility and instill confidence in investigations, or where the incident may have national ramifications, or where such an order may be necessary for doing complete justice and enforcing fundamental rights. Otherwise, CBI would be flooded with a large number of cases, and the limited resources may find it difficult to properly investigate even serious cases, and in the process lose its credibility and purpose with unsatisfactory investigations. I understand. I understand your lordship is concerned by the nature of offenders. But if an offense takes place, and this is something which we've learned from the lordship's time and again, what do? You look at the nature of the offender, not at the stage of conviction, but at the final stage, you see whether the act and not the offense, the act is to fit into some proposition which we call an offense under Indian law. That's all. Now I'm deeply obliged. I don't want to take more time. I'm grateful for your lordship's kind consideration and the humor, not in the grace. That's all.
Can I start tomorrow? Can I start?
Sometimes some of us don't realize when your lordship is, I haven't been before your lordship long enough, realize what is meant is more often than not humor. People take it seriously, not realizing that behind it is grace and humor.
No, humor is, you see, very much required.
To keep us all going, not?
Yes.
Otherwise, how will we manage?
Otherwise, court will be very, in a kind of, court will be in coma, always coma.
Absolutely. Absolutely. I'm so grateful.
Can I start tomorrow? Will not take long.
Yes,
after your lordship sequencing permits.
Yes.
Will be here.
Miss Monica Guruswamy, in the council appealing for respondent, and Mr. Bharat Gupta, Lalit Senior Council, appealing for respondent number 5 in WP criminal number 16 of 2026, concluded their arguments. Post tomorrow, would we say on top of the board?
Yes, sir.
But I will beg to be excused in person. I'll join.
Yes. Post tomorrow, or should we keep it open?
No. Tomorrow, top of the board will be. Generally, that is the practice. I heard it starts at that.
Tell Mr. Sibyl to make a request. Somebody is requesting. I can do it.
I have to pass.
No, actually, हम तो बता देना ऐसे निकालना पड़ेगा एक मिनट
बाकी मैटर after yes
my lord, that bridge corporation matter is there today.
That is
next week.
That is to be dismissed only.
And I have another request, my lord.
Yes.
I filed a note in that matter.
Yes.
I found there were some corrections. Can I place on record another note? I'm
Let
carrying
it remain in the list. It will not be taken up. It will be repeated in the next week.
In the next week, lordship. Tomorrow.
Automatically it will go. It is in the regular hearing list.
Will be repeated. Otherwise, it will repeat tomorrow. Tomorrow I'm in some personal difficulty. I'm just wanting it next week.
Wednesday करना है, next Wednesday करना number.
And Lordship would permit me to withdraw that note and file afresh.
What note?
I have already filed a note long back. I found there were some corrections. Permit me to withdraw that note.
Counsel for the petitioner is permitted to
Note on behalf of the appellants was filed.
to submit fresh note on behalf of the petitioner
And the existing may be withdrawn. Because otherwise there'll be confusion.
after withdrawing the earlier one.
I'm grateful, man.
Yes.
I'm so grateful. Let 10